Item 1, my lord.
Yes.
This is batch of matter arising out of the same order, my lord. And in the meantime, two of the matters which has been heard in part by other coordinate bench, and it is number is 890 of 2022, which has been posted to next week, my lord. 9th February. And another part is, my lord, in WN number 557, which is at sub-item number 3. This has also been stated by this Honorable Court by the Honorable Chief Justice and my lord's coordinate bench. Dated 15/9/2002. Yes, ma'am.
Entry mod.
Yes, ma'am.
But for hearing, no problem.
Yes. And coordinate bench has fixed this matter to
All right.
9.
We'll call this matter. Is it heard in the heard? Matter is heard.
The other bench, identical matter, another bench it was heard. Court number 20.
It is being heard.
Heard, then the government has taken time.
In the third week of.
My lord, I am the intervener in this writ appeal.
Is that measure?
In third week of February, we'll have. Yes. Yes.
I don't know.
Yes. Number 2. Yes.
In this case, my lord,
Yes.
Mr. J.S. Sabra, my lord, is not physically fit to come to appear before
You
this.
want time in this matter?
My lord,
You want time?
I want time
Next.
next.
All right. Call after 2 weeks at the request of Lord Counsel appearing for the appellant. Finally. Next time, no time will be granted. Yes, next. Next. Item 8.
Challenge the order of no single judge. So
Yes.
far, in paragraph 22 of the judgment, my order,
Subject to his being declared medically fit by a duly
Yes,
constituted
ma'am.
medical board.
I have declared medical fit. This Honorable Court has already held. This Honorable Court referred to the AIMS, my lord. I was declared fit by medical board.
Where is that? That you did not tell the learned single judge.
Yes, it is.
Even then, learned single judge did that.
It is as per court's order, my lord. As per the court's order,
Show that.
I'm showing. Let's say Annex of 7, page 19.
Page 19.
Page 19. Let's see, turn to page 20, paragraph 8. Page 20, last paragraph 8.
No, we are asking you to show that you were declared medically fit.
Yes, my lord.
Where is that?
This Honorable Court referred to AIMS, my lord, then in paragraph 8. Then AIMS report, my lord, it has Annex 8, page 22, my lord. I was declared fit by SC Medical College, also AIMS.
Who appears for the OPs?
My lord, it's a Government of India. Government of India.
Of India.
Union of India. I have stopped the copy, my lord.
Issue emergent notice. Learned,
I have already stopped the copy to.
you have said that.
Already stopped the copy, my lord.
How many times you want to say that? You want to say mantra or what? Learned, DSG is requested to accept notice for OP number, all OPs.
All OPs.
Who appeared in the court below?
Yes, ma'am.
He appeared.
Yes, yes, ma'am.
DSG is requested to accept notice for 124. First, appellant to serve copy of the appeal memo along with all the documents on the learned DSG. First one, since matter lies in a very narrow compass, call the same. We come to next. Yes.
Next slide.
Next.
I may be pardon, Your Lordship. I need to examine the records, Your Lordship. It may be posted 2 weeks after.
After 2 weeks.
After 2 weeks, Your Lordship. I need to just go
Can
through
we do
the.
that? Yes. 2 weeks at the request of learned DGA. Finally,
Interim order continue.
entry order you have 4 weeks.
State.
Entry order to continue. Yes.
May I plead your lordship fix a date, my lord, because say it again.
No, you have entry order. Will not fix it. Yes.
Congratulations.
Yes.
This is that matter where the appellant was a disabled candidate and was transferred by violating clause 17 of 21 regulation.
Similar order.
Yes, your lordship had asked us that any medical documents that was there with the department and filing it through a memo, your lordship.
Have you filed did you file appeal before the concerned officer?
Millard, there is no appellate authority, Millard.
No appellate authority.
Yes. We approached by virtue of a writ application. Thereafter, writ application was dismissed and we filed a writ appeal, Millard. Preferred a writ appeal.
Reception was dismissed before my judgment,
No.
which was set aside, MLA's recommendation, etc.
No, Millard.
No, not before.
No, Millard. That is the different issue, Millard. Here the issue is
Yes.
petitioner is a disabled candidate with 45% of locomotor disability. Now petitioner was
This
transferred.
is a case where out of the district it was transferred.
Yes,
Yes,
your
Malaj.
lordship.
When the guideline said preferably.
Yes, preferably
within
in
the-
native place.
Preferably nearby the district
Yes,
or in the.
or at least in the native district. So appointment or transfer in the native district is a sine qua non, according to clause 17.
No, your lordship. That is.
It cannot be sent on because word preferably, last time you argued that, no?
Malaj,
You had shown that and you wanted to split it also.
Yes.
yes, Malaj, on that, I have also perused, today morning I was perusing certain judgments. Delhi High Court's judgment is there where native district is a sine qua non.
Is it?
Because Malaj,
Which is that judgment?
Malaj, just now I was perusing by sitting here, Malaj. That's why I do not have the copy.
Again, first over. Will not cut that.
Yes, Malaj.
First. Item 6.
90 girls.
Yes, Mr. Mishra.
Your lordship, we were, in this matter, the other judges said that we had to substitute the legal heirs, your lordship. The appellants, your lordship, of the opposite party, 2 weeks time may be given or 3 weeks time may be given for us to substitute. Your lordship, because in the meantime, the respondent has
No, not
expired.
in I think my
I think six is the Union of India is the appellate
Oh,
party.
sorry,
No,
your
yeah.
lordship, sorry.
Yes.
Absolutely.
Yeah.
Here, the issue would be very short. Though I have filed a death chart indicating all the details. Here he was initially engaged as a caretaker.
Caretaker.
Yes. Then there was a notification.
What is the grievance?
Grievance is, my lord. He claimed for the post of a group D post as per the notification. There was a dispute with regard to his experience, whether he has completed 3 years or not, and he was not selected. Matter was carried to CAT, Hon'Ble Central Administrative Tribunal. His claim got rejected. He moved this Hon'Ble Court. This Hon'Ble Court again observed that I should move the learned CAT. Now, after I moved the learned CAT, your lordship will kindly turn to Annexure 9. Annexure 9. I'm sorry, Annexure 12, page 44. I filed an application there seeking for recall of the earlier order. My lord got it, page 44.
RA number, RA.
Yes.
On what ground?
But that came to be, that is the point what I beg to point out to your lordship. Page 45, your lordship may kindly turn to. Page 45, paragraph 5. That came to be disposed of saying that you file appropriate proceeding. I had not filed initially review application. I had filed a petition for recall. Recall petition got disposed of granting liberty to file appropriate application. Then the review application order Annexure 13, page 46 has come into existence. My lord got it.
Yes.
So now in the review order, the court says that since I had already rejected your MA, where liberty was granted, this is barred by res judicata successive review.
Which is this judge?
You granted liberty to file an application, I filed, then you say it is res judicata.
But that order was made on merits, earlier order.
Earlier order, liberty was granted, page 45, to file fresh application. So therefore, this cannot be barred by res judicata. The same court granted liberty to file review application.
Take notice.
My lord, I am appealing, my lord.
Yes.
But kindly see the input order page 47, my lord.
47.
Page 47, para 4.
Applicant regarding the-
Page 40, continue with the date petition 47, page 47, para 4. Section 47 of the CAT procedure, Section 17 of the CAT procedure rule 1987 is very specific and deals with regard to filing of review petition. The said function prescribes that no application shall be entertained unless it is filed within 30 days from the date of receipt of copy of the order sought to be reviewed. And the law is usually defined by the Hon'Ble Appeals Court in the case of CHITTARANJAN versus M.N. Naga Sharma, 1962.
Whole period to be covered.
Sufficient cause means given. But this is the case where the limitation.
Here 1960, 2022 is diluted to the greatest extent. 60, perhaps you were not born, I was not born, my brother was not born. Mishra was also obviously.
I was not born.
But the law has...
But on the question of limitation, the matter before your lordship, my lord.
yes. But liberty, why did you give the liberty?
But liberty has been given after 4 years. They have given the liberty. They have not removed the defect. They have filed RA before the tribunal, and sufficient opportunity has been given to remove the defect. That has not been given, and that they have taken the ground before the tribunal. My lord, kindly
No,
see
but the
that
tribunal dismissed the review
question of-
petition on what ground?
on the, my lord, kindly see 48.
Both on delay and
48, my lord, kindly see, my lord.
Rejudicata.
The adjudicator will not happen.
Madam,
But delay.
But that is why your lordship was pleased to direct me to file the review application and the limitation application which I filed on the previous day. May I just point out from the limitation petition I had filed before the Learned Tribunal. Your lordship, if your lordship peruses the conversion of delay petition,
So that is also not plausible. Court say review is rejected on the ground that your application seeking condonation of delay.
yes.
That the explanation offered is not plausible.
Your lordship may see 2018 reasonable court disposed of. 2019 COVID came into existence.
No, that also we discussed. COVID is over a short period, but rest of the delay is not covered.
Now, 2 years, it has been covered. Your lordship will see paragraph. My friend may not join word by word issue. Your lordship is asking me. I am assisting your lordship. He can have his say also. You may kindly see the condonation of delay petition. But this is a lowest post available in railway. He has been fighting since long. But the delay has been, your lordship will see, initially recall application filed, diary number was made. But there was some kind of communication gap with the council that got dismissed. Recall application was filed. Application liberty was granted. Then review was filed. Everything has been explained. But your lordship will see from, if your lordship peruses the condonation of delay petition from paragraph 2 onwards, a practical explanation has been given. And he is fighting for a job which is lowest in the institute, Mal Railway Institute, a caretaker, your lordship. And this struggle is going on since then, and he is no more in job also. If at all they get entertains valid and subject to your lordship's kind consideration regarding delay condonation, then only he may get back job. So this is my situation. If your lordship kindly peruse from paragraph 2 onwards, and there has been a plausible explanation. I understand my friend's vehement opposition with regard to the delay.
That has been
Your lordship
explained
kindly
in paragraph
peruse.
in detail.
My lord?
In paragraph three, they have explained in detail how long you have taken for removal of defect.
Your lordship, I have explained. My diary number was made. That was also 2 weeks time to remove the defect. Then COVID situation came. There was no communication. And all those things are COVID situation. Your lordship has been pleased to. That is 2020 to 2023. That 22. That period, your lordships have been pleased to hold that. That's a period where the limitation will not be counted.
No, is it from 2020 to 2020?
No, but thereafter your lordship will see, I have explained. But that was not in my knowledge and all. But this is what I can present it for your lordship.
Nothing. Discussion.
As your lordship.
No. This petition by the candidate seeks to lay a challenge to the Central Administrative Tribunal order dated 16/4/2024, whereby the review application is rejected because the delay has not been condoned and office objections were not addressed. First. Next one. Learned senior advocate Mr. Mishra, appearing for the petitioner, vehemently argues that the grounds on which the impugned order is are not sustainable in as much as earlier liberty was granted and therefore the doctrine of res judicata would not be applicable. Some extent. The COVID pandemic 19 intervened and therefore delay has to be very leniently considered. First of all, he also tells the court that Section 21 of the Administrative Tribunals Act 1985 is liberally construed by various high courts in the country, and that liberalism is not reflected in the impugned order. First, the learned CGC appearing for senior panel counsel appearing for the Union of India and its officials stoutly resists the petition making submission in justification of the impugned order and the grounds on it has been constructed. First, he draws attention of the court to the contents of paragraphs 3 and 4 of the impugned order to substantiate his stand. First one. Next, having heard learned counsel for the parties and having perused the appeal paper, this court, we decline indulgence in the matter, broadly agreeing with the reasoning of the CKT Cutter. First, that the paragraphs 3 and 4 of the impugned order, the tribunal has observed 3, 4, 5 of the impugned order, 6 also. 3, 4, 5, 6 of the impugned order, the CAT has observed as an first of all, that produced below one line. We are in broad agreement with the observations here in above. First, in the above the next paragraph. The vehement contention of learned senior advocate Mishra appearing for the petitioner that when liberty is granted by the order, the doctrine of res judicata has to stay miles away is a bit difficult to countenance. First, merely because liberty is granted, that does not mean a citizen can wake up from the deep slumber and approach the tribunal at any time whenever he wants. The sages of law have said that the law of limitation is a law of peace and repose, and therefore there should be finality to the list in the best interest of the society itself. First off, the tribunal found the explanation offered for the delay proved in approaching it is not plausible. It's true. First off, however, tribunal also in the earlier orders mentioned about discussed about certain things that would eventually amount to res judicata, going by any standard book on the doctrine of res judicata. First off, after all, the doctrine of res judicata that operates in the high courts and the tribunals is a bit wider than what has been enacted in section 11 of CPC 1908, said the apex court. First off, next one. In the above circumstances, petition being divide of merits is liable to be and accordingly dismissed. Courts having been made. Next.
My lord, as per this Hon'Ble Court's order dated 22/12/2025, I'm praying for 2 weeks' time to file the affidavit.
When time was granted? When you were supposed to file the affidavit?
My lord, we are missing out on some important documents. And
We don't know. Time was given to you. How many times the division bench should give time for you?
my lord, I'm praying for last chance.
No, you pay 500 rupees to the advocate welfare fund, will give you. a period of this court-wide, the coordinate bench of this court-wide order dated 22/12/2025 had given time to do certain things, which the petitioner, appellant, petitioner has not done. First off, counsel for the petitioner seeks one more accommodation. First, courts are not meant for giving adjournment after adjournment. When there is public criticism against dragging of the litigations, rightly, first off. Next paragraph. In the above circumstances, a period of 2 weeks is granted to the petitioner to comply with the order dated 22/12/2025 on payment of ₹1,000 to the Advocates Welfare Fund.
May I pray for 5 minutes?
No. Advocates Welfare Fund. But which is that? Is there such a fund? Okay, full address and other. Failing which the petition itself may be dismissed on that ground. Yes.
Item number 8.
Your Lordship, by an IA, the respondents had filed for the benefit to be extended to the legal heirs, Your Lordship. On that day, the appellant came to know about the fact that the respondent had died in 2023, Your Lordship. So we seek time, 2 weeks' time, so that we can substitute the legal heirs.
The power, my lord.
Power of whom? So your appeal is of state.
Yes, yes.
Yeah, state has to file no application for bringing the LRs of the deceased.
No, by the time he had filed this, it was not in our knowledge that the appellant had, the respondent had expired, Your Lordship.
The respondent died.
Pure my lord.
What is that? The client is dead and gone. Your wakalat also has gone. Right now. This is the state appeal against the order dated on the order of the learned single judge. Dated 2/12/2022, 2/1/2024.
1/2024.
Learned AGA, Srimati so submits that the respondent having died, the petition appeal would await if LRs are not brought on record, and therefore a short accommodation be granted. Custom. We agree. Cause this matter after 2 weeks.
Oh, bless you,
Yes.
Item number 9.
May I please, Your Lordship?
Yes.
This is a matter. This writ application has been filed by the state, challenging the order passed in WPC way of 180 of 2017, disposed on 1/10/2023.
Yeah.
On the ground that, two ground mostly they have taken. One that...
Why were you before the learned single judge? What relief you wanted at the hands of the learned single judge?
No, the single judge has allowed the...
No, what was your read before the single judge?
The read petition was about relating some disciplinary proceeding.
Disciplinary proceeding. Your claim.
And that was allowed in my favor. That the order on 10/2/2023. After 444 days of delay, they have filed the writ application. On basis on two grounds. One is that...
Let him argue. His appeal.
Yes, that has been condoned. But the basic thing is that on the ground that the Honorable Single Judge...
to argue.
My lord,
Who is the appellant?
I am the respondent.
Then keep quiet. Let him argue. There is a method.
I have filed a IA.
Yes.
And that is to be heard today.
What is that IA?
That IA, there are some orders which is contrary to the factual position of the case. That's why I have filed the IA for correction, rectification of that order. It is in accordance with...
Passed by the Honorable Coordinate Bench, Division Bench of this Honorable Court. That is Lordship's order dated number 17th September.
17/9/25.
Yes, order number 3. There is two order on that day.
79?
17/9/2025, madam.
The IA number is 4198 of 25.
There was a order, this order of the coordinate bench, which required certain thing to be done. 17/9/2025.
Yes.
They have made some caustic remarks against your against the registry. Anyway,
That is not unchallenged.
huh?
The order number 3, there is 2 order in that particular day. But one is 4 and one is 3. 4 is all about the registry and 3 is all about the registry. And order number 3, I am concerned.
Order number 3.
Two orders on that particular day.
Same day.
Yes. Order number 3 is relating to me. In that order, some inappropriate factual matrix has been crept into in that order. And in view of the order of the Honorable Apex Court, since this your lordship knows it is the court of record, some material correction is required. So I beg for certain ratification in that order. On the ground that there is 2 points only. I don't take to take too much time. One is that the London State Council says that there is no time, no opportunity was given by the Honorable Single Bench when deciding the case. Actually, 7 years have passed, giving full opportunity to the state. They didn't file counter in that case. That is number one. The second case is that after my retirement, a vigilance case is the cognizance has been taken. In the division bench that has been decided that after the date of retirement, the cognizance is not material for payment of pension. That is the factual position. These 2 points has been crept in the order that is order dated 17/9/25. So
Infirmity is
First infirmity.
first defect is.
First defect is that this London State Council says that the case in WPC 1802 of 2017 has been disposed of at the stage of admission without giving opportunity to the State Council, to the state. And that has been recorded in the order. But actually,
He was heard in the matter.
yes, several opportunities has been given. It was filed in the tribunal. It was filed in 3/11/2017, and on that very day, it was stayed. The impugned order was stayed. The State Council was given opportunity to file counter. Then after Orissa coming over to the case to this Honorable Court, twice opportunity has been given to file counter. And in the meantime, they have implemented the order. By the order of Honorable Governor, they have passed order to implement the order.
Where is that?
That is there. Annex 10.
Have you implemented the order retaining right to continue the litigation?
My lord, there was a vigilance case initiated against
We are
the
asking a
project.
question to you. What we are asking a question to you. Did you implement the order of the learned single judge under threat, coercion, like contempt, etc.? Or on your own you implemented and retained the right to prosecute the appeal? Because ordinarily, when writ is implemented, right to challenge withdrawal. Unless you say that we are implementing this because we have threat of contempt, or that we are implementing, but we will continue subject to outcome of our appeal. Where is that implementation order?
Page 10. My counter has been filed by me in the writ appeal.
You have produced the implementation.
Yes. I filed Annex A.
Counter affidavit.
Counter affidavit.
Annexure?
Filed by the respondent.
Annexure?
Annexure A.
All along he has suppressed that a vigilance case was initiated against him, my lord. That was initiated in the year 2013, my lord. And he has superannuated in 2014, my lord.
Yeah.
And prior to that, that was a departmental proceeding. And departmental proceeding was concluded, my lord. And the vigilance proceeding is still pending, my lord. And the charge sheet was filed, my lord.
No, but why did you implement the order? Have you implemented order of the learned single judge? That is the question. What was the order?
Order was the challenging order. The order was
What was
challenged.
the order to be implemented?
The order to implement it. That is also decided by a division bench. That record is available in the
This, we are asking a question to you.
Page number 9.
Question is of language, little of law. What was the order of the direction in the impugned order?
direction was to quash the proceeding.
And that came to be quashed.
Yes, because that was the based on the order of a division bench.
And whether there was any further direction after
Yes.
quashment.
Yes.
What was that direction?
That-
Go to the impugned order.
Coming to that, I want to say that what they say about the cognizance, actually the cognizance were taken on 28/4/2017, long after my retirement. I retired on 31/3/2014. And my
Go to the
paper,
impugned order.
The relevant page is ballot, page 30 ballot of the appeal memo ballot. Page 26, page 30 in the circumstances ballot.
If within time, suppose a court prescribes particular periods to accomplish the disciplinary inquiry. I'm giving an example. You don't understand English.
yes, I understand, but I didn't hear
You
you.
have to lend your ears to me. Then you will understand. We are come to para 9 of the judgment. Tell him in your Odia.
Para 9 of the judgment, input
Yes.
judgment.
Yes.
Come to that.
Page 30 ballot.
Yes. The court is inclined, inclined and relying on the aforesaid decision rendered by this court by the division held that since the subsequent disciplinary proceeding has not concluded within that period, it is.
Correct.
Yeah, but
Yes, that is the order, yes. Has not been concluded within the period specified by the London Tribunal while disposing of the way
Period number so and so.
4 of 2016.
What was the period granted to?
Was 2 weeks.
2 weeks.
2 weeks. That was the period given. That is there in 29, page number 29.
Still then there was a department, vigilance case is initiated.
Vigilance
still
case
pending.
story is altogether
It's
different.
criminal case, my lord.
Did you seek extension of the period?
No.
Court prescribed
Lord, sir.
a limitation period. Ordinarily, the legislature, parliament, they prescribe the limitation. But certain cases,
Yes.
court also prescribes time, which section 148 of CPC.
Lord, sir.
Court can, or even 151, court can prescribe time for doing particular things.
That,
No, you're asking,
that's
I'm telling,
Lord, sir.
so that the logic is developed. And you do not do the thing to be done within that period.
Lord, sir.
Nor you make an application under section 148 capital A of CPC seeking extension of the time. And such application could have been made after 1976 amendment, even after the expiry of the period. You did not do.
Lord, sir.
And now what is wrong with the order?
Yeah. My lord, nothing wrong, my lord, but
Then why are you
what's that? The lordship, this is a departmental proceeding. Prior to that, there was a criminal proceeding.
That's all right. On that ground, we could
How
have
the
gone for
authority
extension.
will disburse the pensionary benefit, my lord.
But who prevented you to take an extension? A
That's-
stipulation was
that-
there
that-
that you have to complete the display actions within 2 weeks.
That's-
You could have gone for an
We have
extension.
gone to the court and said 2 weeks are not sufficient. We are launching a satellite and therefore we need about 20 years.
They have concluded the departmental proceeding, my lord. But still the vigilance case is there, my lord. For that reason,
That we do not do.
his pensionary benefit has not been granted.
This infra-court appeal by the state and its officials.
Lordship have been called for the report from the vigilance.
We do not want anything now because apparently the order is perfect. We'll assume that vigilance case was pending.
Lordship.
How that is going to add merits to your case? That could have been a ground for seeking extension of the period. That you have not done.
He all along will suppress that fact. He brought the tribunal before
That's
the
all.
honorable court.
Question is not that. Court has prescribed the period. You should have got it extended
Lordship.
by telling all these things. You have not done that. Order remains intact. The best way is to withdraw the appeal with liberty to move the CAT for extension of the period. We'll make that observation so that it's a serious matter where you can go for this one. We will give liberty to them to seek extension of the period before the CAT.
That is, 3 another cases has been developed in this meantime.
Maybe.
Actually, the law, it has been now taken the step of a law that if a government servant is having some disciplinary proceeding or criminal proceeding on the prior to date of his retirement, that will count towards his non-payment of annual pension.
Right.
But if the cognizance is taken after the date of retirement, that is not a bar for payment of
You
his
take
pension.
up all contentions when they seek extension there. 2 years granted, because 2 high courts have taken conflicting view. One high court said, where period is prescribed for accomplishing the disciplinary inquiry, and within that period, disciplinary inquiry is not accomplished, the order of penalty is not a nullity. One high court has taken that view. Justice Patti of Kerala High Court. Another High Court of Allahabad High Court, Justice Dhawan of Allahabad High Court has taken the view. Merely because within the period they have not accomplished, that will not invalidate, that would invalidate the proceeding itself unless the extension is sought for and granted. Therefore, what we say is, we are making some order saying that we will not interfere in this one.
The Honorable Division of this court, in an earlier case, relying on the decision on the Honorable Supreme Court, has said that you have not done what you have been said to have been done.
Correct.
So you are liable. This for the order passed by you is to be quashed. That is the another aspect is there.
The
But only
state and its officials are knocking at or in an intra-court appeal for laying a challenge to a learned single judge's order entered in WPC OA number 1802 of 2017, filed by the OP respondent herein, wherein a challenge was laid to the order of disciplinary proceedings. First one. Next paragraph. Learned AGA appearing for the appellants submits, and the learned counsel appearing for the respondent disputes that the learned single judge grossly erred in quashing the very disciplinary proceedings on the ground that the period, the same has not been accomplished within the period prescribed by the tribunal in OA number 44 of 2016 that was disposed of on 25/4/2016. First, learned AGA submits that an order passed in a disciplinary inquiry even beyond the period prescribed by authority or the tribunal is not a nullity, and this aspect having not been duly discussed by the learned single judge, the impugned order as an infirmity apparent on the face of the record, and therefore is liable to be voided. First, learned counsel appearing for the respondent controverts the legal proposition. Next paragraph. Both the sides draw attention to the to some orders made by coordinate bench of this court during the pendency of the appeal. First off, we need not much advert to them since matter lies in a narrow compass, and a kind of reprieve can be granted to the appellant, which aspect we will discuss here in after. Next paragraph. Having heard the counsel for the parties and having perused the appeal papers, we decline indulgence in the matter for the following regions with some reprieve as under. A. The respondent was implicated both in a vigilance case and in a service misconduct. First one. Therefore, he was subjected to certain disciplinary inquiry, which was put in challenge in OA number 44 of 2016 by him. It was your OA.
No, the
OA was whose?
previous OA 44.
What was your OA?
Yes, but that was not the matter relating to criminal proceeding.
You have said it 10 times now. Yes. The CAT, Cuttack, wide order dated 25/4/2016, had directed accomplishment of the disciplinary proceedings within a short period of 2 weeks.
No,
How many weeks?
we'll think that.
May not be 2 weeks generally. Where is that order?
Given 2 weeks.
Within a specified period.
That's it, page 24, my lord. 2 months, madam.
2 months.
Months, madam. Within a period of 2 months.
First one. That order was made after fixing the competing equities involved, namely the public interest of the administration and the private interest of the retired employee. First one. However, the disciplinary proceedings were not accomplished within the period specified, nor any extension at the hands of the CAT in terms of, in the line of section 148, capital 148 of CPC 1908 was approved. First one. The authorities assumed to themselves the jurisdiction to pass the penalty order and passed one beyond the period specified by the CAT. First, the apex court in AR 1992 SC so and so has held that an order of the court or tribunal, even when is bad in law, would continue in operation for all ostensive purposes unless recalled, modified, or otherwise varied. First one. Therefore, learned single judge was right in granting relief. Next point. Learned single judge, while granting relief to the respondent, has observed at para 9 of the impugned order, 9 and 10 of the impugned order as under. First one. We do not find any infirmity in the said order, in as much as the order challenged before the learned single judge was beyond was passed beyond the period specified by the tribunal in OA number 44 of 2016, as already discussed about. First one, it hardly needs to be stated that the tribunals established under the provisions of the Administrative Tribunals Act 1985 are almost a substitute for the High Court because of the wide L. Chandra Kumar versus Union of India. First one. Therefore, orders cannot be lightly taken, and that they have to be treated as if the writs of writ courts. First one. Next one. In the above circumstances, this appeal being unworthy of merits is liable to be rejected, and accordingly it is. First one. However, in the special peculiar circumstances of the case, liberty is granted to the appellants to seek extension of the period at the hands of the CAT, which had disposed of OA number 44 of 2016.
That was an OAT, no?
Wait,
OAT.
Now that
Not CAT. No, that's OAT.
now OAT is abolished.
abolished.
Then
State
Then
all the cases are
before it
transferred
will
to
be
this.
single judge. Single judge. OAT, which is not the comma, which is since abolished, comma, before the learned judge of this court, before the jurisdictional bench of this court.
Division, it will come before
We do
division.
not, we do not. What extension? Because it's not a challenge, it's extension. I don't tell. Come on, if grounds do it, it's there. But all the intentions of the OPs, parties in that regard are kept open. Yes.
That it may be fixed a deadline so that I can get my pension. If they don't do within a particular time, my pension paper should do.
Within a period of 4 weeks. Within 4 weeks, you have to approach the.
6 weeks, man.
Right?
6 weeks.
Why 6 weeks? Already you have covered it in efforts. Next. I don't tell.
My lord, I am the respondent.
Yes.
I am filing, my lord, the objection to the IA delay contribution.
It's the registry is there, where the objections are filed.
My lord?
Registry, there is registry.
My lord.
So you cannot ask the judges to do the job of the registry.
Sorry.
It becomes a notional extension of the registry. It is not.
Sorry.
All right. You will give some time to you file there. All right. This is appeal by whom?
State.
10 is a state appeal.
Lordship.
Anything is there.
Yes, my lord.
Yes, say.
Lordship.
How many days of delay?
447 days, my lord.
Yeah. We are dismissing it on that ground.
Lordship, delay has been condoned, my lord.
Already condoned.
Lordship.
What is that IA now? 6034 of 24? Dispensing filing of C copy. All right, say.
Lordship, that is in order dated, my lord.
No, that's all right. That is condoned.
Yes, my lord.
I
3rd
will
July
go by that.
2025, my lord.
All right. What are the merits of the case?
My lord, the respondent, my lord,
Yes.
was
This is writ appeal, brother.
little my lord.
In writ appeal, you want to file the objections. Is there provision in your rules?
Delay, my lord.
Delay. But delay, he says condoned.
Condoned since July, my lord.
No.
2025.
Is it condoned without notice to you?
No, my lord.
I'm sorry.
you are not sure whether the application was heard in your presence or not.
Right. That is no other cases.
No, delay not condone, my lord.
Condoned already, brother.
Man.
No, you cannot file. Yes, brother. Tell on merits. You have to take little, we have to ration our time.
Lordship.
If you take a long time, all have to wait. And tendency will go up.
No, he has filed for objection, therefore.
That question will ask. Ignore the objections.
That's why I'm indulging my lord's attention towards my lord, my date chart, my lord.
Which is the order by which delay is condoned? Tell the date of the order.
No, my lord, delay has not been condoned. Some other file, yes.
Not condoned.
Because only order is seen here.
No order.
Is order dated 17/7/25.
Well, Khandapura, no, you perhaps you are arguing some other matter. Some other matter you are arguing. Delay is not
There is no
condoned.
order. That is not-
Then he is justified in filing objection to the delay.
Lordship.
Just give that.
My
But you have to always file in the registry. So
sorry.
as a concession, we are
That's all.
accepting that. Take that. How many days? 400?
474, my lord.
474. Yes, pay brother 200 rupees per day. Pay him.
Lordship, my lord's order in
What you have said?
condone the delay, my lord, in other case.
Delay condone.
Yes.
In this case?
No.
In this case.
The orders are case-based. They are case under some principle is this.
Yes, sir.
It's a case-based order.
And order is there for that thing.
You pay 200 rupees per day, 474 into 2, it will be.
Lordship.
8,000 plus 740, 9,480.
Lordship,
You pay 9,480, then we'll hear this.
Lordship, I say 100.
Huh?
100.
No. Your state is a rich state. They are poor. You pay to council.
Lordship.
You condone the delay, subject to payment of 10,000 rupees to you. This intra-court appeal is filed calling in question a learned single judge's order dated so and so, entered in respondent's WP number so and so person. An application is filed seeking condonation of a delay of 474 days in filing the appeal, and the same is supported by a person. The usual grounds of a bureaucratic process are mentioned in the application stroke affidavit. First, learned counsel for the learned AC appearing for the state and its officials argues that delay should be viewed very leniently, especially when the cause of state is involved. Semicolon. If delay is not condoned, injustice and hardship would be caused to the state. First one. He also adds that if delay is condoned, that would not add merits to the appeal to the disadvantage of the respondent. Semicolon. What would happen is that the appeal would be heard on merits, wherein all contentions can be taken up by the others. First one. Next paragraph. Learned counsel appearing for the respondent vehemently opposes the application, contending that so far as law of limitation is concerned, it treats Crown and the citizen on par with each other. Semicolon. Barring a few exceptions that are absent in this case, there is absolutely no reason to show more leniency to the state. Semicolon. The explanation offered for condonation is not sufficient, is not plausible, and therefore he seeks dismissal of the application. His objections in this regard filed this day in the open court are noted. Next, having heard learned counsel for the parties and having perused the appeal papers, we stand in between two extreme views canvassed at the bar. First off, justice of the case warrants that delay be condoned by allowing the application. Of course, subject to doing some justice by awarding a certain sum of money in favor of the respondent who is a poor citizen. First off, in fact, justice of the case warrants such a balanced position. First off, in the above circumstances, the application having been favored, delay is condoned, subject to the appellant number, which appellant will pay.
In the
Three,
4 million.
Four, subject to appellant number 4, paying to the respondent a sum of rupees 9,480, computed at the rate of rupees 200 per day of delay within 2 weeks, failing which the application stands rejected, and as a consequence, the appeal shall be deemed to have been rejected. Not after 2 weeks for formal compliance.
Not
For the
fixed date.
let it come after 2 weeks. Some date that we can fix. Next, item 11P.
May Your Lordship.
Yes.
But the present intercourt appeal has been filed by the state.
To pay to the council for the respondent.
But the present intercourt appeal has been filed by the State Council for Technical Education and Vocational Training, challenging the order of the Honorable Single Judge.
You are the counsel for appellant.
My lords. And there is a delay
I have
of
entered appearance for the.
for 13 delay of 13 days.
Now what is the delay?
13 days, my lord. Delay.
13 days.
My lords.
You pay 130 rupees to him. Or 1300. 13 days.
13 days only.
We'll condone delay.
I don't get
Yes.
objection to that. 13 days.
Yes. What is on merits?
Your lordship kindly come to the order of the Honorable Single Judge.
Appeal intra-court appeal is filed after booking a short delay of 13 days and an application supported by affidavit accompanies the same seeking use condonation. First, delay is short and explanation offered is plausible. First, other side very graciously agrees with this field. First, in the circumstances, application is allowed and delay is condoned. Yes. This is the
But that item 10, 474 days, 200, that amount will be higher. 94,000.
That should be 110, it should be. You are right. You are right. You are right. Yes, it's the rate of 10 rupees. Yes, sir. 20 rupees. The rate of 20 rupees. You are right. Yes. I was bad in arithmetics, even like that. Yeah.
But here, the Honorable Single Judge, my lord, directed to regularize the service of the present respondent, my lord.
How many years of service he has put in?
My lord, he has put in, my lord, since 1988, he was continuing. But, my lord,
88.
my lord, your lordship may kindly see the background. He was never appointed against a regular sanction post. Initially, he was working as a job contract employee. In 2000,
Jago.
my lord, in 2007, my lord, some 21 number of contractual posts were created, my lord. So in 2007, she was appointed.
You made him to work. You have sucked his blood, sweat, everything for France since 1988.
And
Perhaps you were not liar at that time. Were you liar?
In 1999, I mean.
10 years after he gained entry. No.
Lordship, because there is no regular vacancy created.
All this is looked after by our other judgment of electricity. Jago, Dharampa, which you have followed in another.
There are availability of regular post, my lord.
No.
Here,
We say contention as to non-availability of the regular post cannot be taken if the employee is made to work for decades. I remember the sentence. I drafted that. That contention is not. What is that post, etc.?
And one of the similar issue, my lord, arising of the appellant's organization is pending before the Honorable Supreme Court. Wherein the matter has been referred.
You can take this also to the.
My lord, wherein this has been the SLP has been referred to a larger bench, which is pending, and it has been fixed to February of.
No, whatever it may be. Right on. This intra-court appeal seeks to lay a challenge to the order dated so and so made by the learned single judge in respondent's OP number so and so, whereby the relief has been granted by the learned single judge of regularization in the following words. First, operative portion introducing. Learned counsel for the appellants vehemently argues that the impugned order is liable to be voided in as much as the learned single judge failed to appreciate that no regular posts were available and that available, semicolon. He also very fairly tells that as many as 17 contractual posts were created in 1996.
2007, my lord.
2007. And therefore, the question of ordering regularization would not have arisen before the learned single judge. First, he also presses into service the apex court decision in State of Karnataka versus Umadevi, ML Kesari, etc. First, you appear for whom?
And for the
Respondent.
employee ballot.
You want to say anything?
Now what your lordship is the ballot service and what I have tried.
Learned counsel
Completed
appearing for
33
the
years of service.
respondent employee resists the petition contending that his client gained
And in addition to that, similar situated person, Supreme Court has confirmed.
way back in the year 1988, and since then decades have lapsed, there being not even a single black spot in the service record. First time. He also cites a apex court decision in Jago and Dharmapal in support of his contention. Next, having heard the letter counsel for the party and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge. First off, the first off, our constitution has been amended by introducing two words, socialist and secular, to the preamble by the 42nd Amendment, 39th or 42nd Amendment, in the year 1978. First, since the introduction of this word socialist, the system is lurching towards the labor and men in service. First time. Otherwise, that word would be an empty, would be a case of much shadow signifying nothing. First time. The next paragraph. The first contention of learned counsel appearing for the appellants that there are no courts against which regularization can be granted is liable to be rejected because such a contention cannot be taken up after the lapse of more than 4 decades.
So initially,
88.
No, I was wrong, 2000. 2000 initially engaged as a job contract employee, and 2007, she was.
Judge learned single judge says more than 33 years.
But in fact, you also may kindly see the page 82. It is maybe
2000.
2000. Right?
I stand correct, 2000. That they have stated in the browser itself, page 56.
Then
That is on 2000.
2000. First time. Now we are in 2024, 26. First time. It is not the case of other side that the services of the respondent were were unsatisfactory or otherwise. First time. If a person is if the services of a lady candidate have been taken by the appellants for a period exceeding 2.5 decades, it does not stand to justice that regularization should be denied to her. First time. Learned counsel appearing for the respondent employee.
Giving a pause here, Bernard.
Justified.
Admitted that there are vacancy on contractual basis from 2007. That's what they have stated.
She has been continuing on contractual basis. From
Again,
2007. That's a contractual created as contractual.
Processing and service tradition of apex court in rightly processing to service tradition of apex court in Jago and Dharmapal. First up. A coordinate bench of this court has also followed the said decision scrupulously and have taken the view which we have now taken. First. Last. The second contention that in way back in the year 2007, as many as 17 contract, you said 17.
Page 83.
17 ports have been created on contract basis.
Page 83.
And therefore, regularization as such cannot be granted. Is a bit difficult to contain. First, the very fact that ports have been created goes to show that there was requirement for services of employees like the respondent hearing, as rightly contended by learned counsel appearing for the said respondent. First, next one, in the above circumstances, appeal being devoid of merit is liable to be rejected and accordingly it is. First, having been reluctantly made. First time, the order of the learned single judge shall be given effect to within
Your Lordship, please just
within 8 weeks.
I know this.
And compliance report shall be filed with the Registrar General of this court within 1 week next following.
I know this.
Failing which punitive action may follow.
My lord, may I be permitted to submit one more line, my lord?
Yes.
One of the similar employees of the appellant's organization, this case is pending before the Honorable Supreme Court,
Yes,
which is page 87.
Madam,
Any stay is granted.
Stay that has been
It has been
modified.
taken note by the single judge.
The Honorable Supreme
Whether stay has been granted, answer the question.
My lord, no direct stay has been granted, but the Honorable Supreme Court has said they may be allowed to work on contractual basis.
No.
Where is that?
My lord, page 87, my lord. Page 87, I have.
It is an interim order.
Other cases,
Interim order.
My lord, it has not been disposed of till late. Today I have verified.
We have
Similar issue,
interim, we have been taught in law school. Interim order
It's not mine. My lord.
inter partes.
My lord, it's not binding about or
No
not.
law is laid down there.
My lord, I just brought to your lordships.
Learned counsel for the appellant draws attention of the court that more or less a similar case is pending before the apex court. In SLP number
24226 of 2022. 24226 of 2022.
and some interim order has been also made directing continuance of the services of the employee in the contract posts, and therefore the appeal needs to be heard in the light of that order. First off, we do not subscribe to that. First off, reason for this is simple. Interim orders of the court, high or low, are treated ordinarily as inter partes. First off, no law is also laid down in the said interim order that is brought to our notice. First off. Next one, in the most circumstances, right? Item 12.
My lord, may I pray that
Yeah.
compliance period can it be extended?
no, 2 months have given.
8 weeks has been granted.
3 months, your lord.
3 months. Only. Item 12. Yes,
May I please, your lordship? My lord, I am appearing on behalf of Mr. P.C. Das.
yes.
My lord, here the appeal is challenging the order dated 8/8/2023 passed by the Honorable Single Bench in WPC number 35008 in 2022. There is a delay, my lord, also. So a final IA for condemnation of the delay, and delay period is 523 days. My lord.
But that order is made in terms of judgment in WPC 18207 of 2022.
Oh,
Do
sorry.
you dispute that this judgment is not applicable?
Yeah, my
Is
lord.
applicable, huh?
They passed the order saying that previous order judgment, on the basis of the previous judgment, they said it.
Whether that previous judgment is not applicable
Not
to you.
applicable to us.
Why?
So that happens, the registered cell deed. So the respondent, what they did, in spite of the registered cell deed, they have given a registered power of attorney saying it to be the registered cell deed. And the mutation case was allowed in their favor. So subsequently we went in the mutation appeal. And the mutation appeal also came in our favor.
Full stop, comma, something should be there. Na? We have to process your sentence.
Sorry, my lord.
Huh? Make it now sentences one by one, giving pause. We are asking you whether decision in WPC 18207 of 2022 had the same similar facts or not?
Not similar fact, my lord.
Why do you say that?
Actually, that has been a registered power of attorney has been placed, my lord.
Where?
So if it has had been the registered cell deed, then it would have been applicable to us.
Well, see, whether that registered power of attorney transferred the interest in the property or only appointed the agent.
They transferred the property, my lord.
Then it partakes the character of sale, 2012 Supreme Court, Justice Ravindran's judgment. See, whether you call it power of attorney or you call it sale deed, nomenclature is not the basis. What actually parties have done, recital. The contents and intent of the parties will decide whether it is a conveyance or not. Merely writing sale deed may not be sale deed at all. It may be an agreement. like this. Merely saying that it is only registered GPA, that will not help you. Suppose if the GPA creates interest in the property, to that extent it partakes the character of a conveyance, said the Supreme Court through Justice R.V. Ravindran.
General power of attorney is not related to this case, my lord. It is something else. The mutation in the mutation case, my lord, it was undervalued, and the registered sale deed was under the custody of the IGR. So what they did, in spite of the RSD, they kept some registered power of attorney, saying that it has the registered sale deed, and the mutation case was allowed in their favor.
But
so we subsequently,
at para 4 you said that that judgment is applicable to your case. You have taken up that contention. Learned State Counsel, on the other hand, though did not dispute to the factual aspect herein, however, also contained the principle request to be decided. Petitioner accordingly submitted the judgment of this court dated so and so is squarely applicable to the case at hand. Para 4. State has specifically said it is applicable. You were respondent in the writ petition. Where did you dispute this position? Not disputed. You are not disputed. Then file review. If you are not disputed, what is the infirmity in the order? All right, in your appeal memo, show us the ground that you have taken that decision is not applicable.
I have not gone through it, my lord. Mr. Das was appearing that time.
We do not know. So, now in appeal memo, have you taken up the contention? Learned single judge erred in applying decision in the WPC 18207 of 2022. Then
not a single sentence in the ground.
There is nothing.
One need an adjournment. I'll come.
No, we don't do on installment basis. We are not banks. How many days delay?
523 days, my lord.
What is the explanation?
There was a communication gap between the previous council. So there was a delay.
Not communication gap. Everybody will have communication gap. In
previous council was suffering from paralytic attack. So the appellant could not have received any
paralysis. Any certificate is there?
So far I have heard from the appellants.
Where is your affidavit? What you have said in the application? Are the affidavit supporting the application?
There is a communication gap between the conducting advocates and the appellants. So on 7/2/2025, when the petitioners made an inquiry regarding the status of the case, came to know that WPC has already been disposed of. So
where is the paralysis? You said.
We have not mentioned in the
why are you misleading the court?
So sorry, my lord.
I'll impose cost. Will impose cost of rupees 1 lakh.
That we have heard from the.
Where you have not mentioned anything in your affidavit.
No, we have never mentioned it, my lord.
Do you know the first principles of advocacy? You are an appellate lawyer or a original side lawyer. Can you say something which is beyond the record?
Sorry, my lord. Extremely sorry.
What extremely sorry? You pay cost of rupees 1 lakh for misleading the court. We believe and we do not turn the pages also. And one such black sheep will make us turn the pages of every case. And we will not be able to dispose of 5 cases a day with lawyers like you.
Sorry, extremely sorry, man.
This intra-court appeal by a private respondent in the private opponent in the petition in the case seeks to lay challenge to a learned single judge's order dated 8/2023, whereby which respondent had filed the WP?
Respondents.
WP?
Two.
4 to 6.
456 million. Respondent number.
WP number
35008.
35008 of 2022. Filed by respondent numbers 4 to 7.
4 to 6. 4 to 6.
4 to 6. has been allowed. First off, the operative portion of the order reads as under. First, next paragraph. Learned first one. Next paragraph. Appeal is filed. This intra-court appeal is filed after booking a long delay of 523 days. First up, an application supported by affidavit in IA number so and so has been moved, seeking its condonation. First up, very vague contentions are taken up in the subject application stroke affidavit, saying that there was communication gap between the counsel and the appellant hearing. First up, what is that communication gap? How that came in the way of preparing the appeal in question, etc., are not stated. First up, there is always communication gap between two individuals in a society. First up, that cannot be helped. Absolutely no reason is assigned that would justify following up the application. First up, therefore, application is rejected. First up. Next paragraph. However, since contentions have been advanced on merits, we need to address the same. Despite rejection of the application for condonation of delay, which automatically would have resulted into rejection of the appeal itself. First off, learned counsel for the appellant who is not satisfactorily prepared in the matter half-heartedly submits that the learned single judge grossly erred in following decision in WPC number 18207 of 2022, disposed of by another learned single judge of this court, wide order dated 26/7/2022. First off, not even a contention is taken in the appeal memo in this regard. First off, the appeal memo does not say that how the fact matrix of the writ petition treated by the learned single judge is much different from that of WPC 18207 of 2022. First off. Next paragraph. Learned single judge at paragraphs 4 and 5 of the impugned order has observed as under. First off, the above observations are inexplicable. First off, next paragraph. In the above circumstances, appeal being absolutely devoid of merits is liable to be rejected, and accordingly it is. Costs having been made reluctantly easy. See, state please also. Registry to send a copy of this order to respondent numbers 4 to 7 by speed post immediately. Yes. Item 30.
Published.
Yes.
Item number 13, my lords.
Yeah.
The conducting counsel is on his legs in another court, my lords. This is with regards to limitation, my lords. There is a 20 days delay period, my lords, which needs to be condoned, my lords.
20 days delay? 20 days. Mr. Mukherjee, you are appearing for the OPs.
I was in KV8, yes, my lords. The writ petitioner, I was in KV8. So I have been served with a copy. I filed no objection.
All KV8ers?
To the development
Mr. Mahapatra appears for Cuttack Development Authority. Respondent number 1. Respondent 1.
I have a preliminary objection to the appeal, my lords.
4 is Mukherjee's client. 5. 5 is not there.
In one, I'm in 4. The other, I'm 5.
The two connected writ appeals, my lord.
Okay.
846.
So all parties are represented.
No. My preliminary objection is that the present appeal is by a person not competent to file the appeal.
No, that's
he was not.
Condonation, for that purpose, I was asking you whether all parties are represented. Both the sides are represented.
So far as
Municipality is not there.
So far as 1, 2, 3 months, I'm appearing.
Municipality who appear.
Municipality, someone appear.
All right. We will condone a short delay of how many days?
20 days.
20 days. In both the matters.
Both the matters simultaneously filed.
These intra-court appeals having been filed after brooking a short delay of 20 days. First, applications supported by individual affidavits have been filed seeking its condonation. First, all the parties are represented. First, next paragraph. Delay is short and there are some arguable points for consideration. First, no prejudice should be caused to the other side if the same is condoned. First, much prejudice is likely to be caused to the other side if delay is not condoned, in as much as if the appellant should be out of the court. First, next, in the above circumstances, applications have in IN number so and so having been favored in both the appeals, delay is condoned. First off, we'll push this matter some other day.
There is a IA 3758 of 25 which I have filed.
IA for
rejecting the appeal because it's been filed by an incompetent person.
Let us see what that they have to appeal. That's what. But,
So that application they have, there is no.
Can it be first week?
First week of February.
Second week of February.
Second week of February. All this matter.
Sitting with the construction.
No,
That's what
construction. There is no question of construction. There is a false statement being made. Let an affidavit to that effect be filed.
My lord, we say on the instructions of the client.
All right, second week we'll have that.
Dates as per your lordship's number.
Call this matter in the second week of February as requested at the bar.
Great.
Item 14. Yes.
May I please, madam?
Yes.
My lord, the humble appellant was the petitioner in the before the honorable single judge.
Your petition is rejected.
My lord.
What was your grievance before the single judge?
My lord, my grievance was inaction of the opposite party number 2 and 3 in recording my name as the legally wed wife of opposite party number 4, who is an Air Force officer. Your lordship.
In the service records.
My lord. In the service record, I applied that because I am the married wife and my husband is not taking care of me, he is ignoring me. Therefore, I appealed before the authorities.
What is the department?
Indian Air Force.
Air Force.
And what happened, the authorities took cognizance of the matter. They reprimanded the opposite party number 4 for not informing the authorities that I am the legally wed wife, but they didn't enter my name. What they did, your lordship, very peculiarly, in the year 2015, they allowed the opposite party number 4 to remarry in the year 2013 by producing a fake divorce paper of 2014, your lordship.
Fake divorce paper?
Divorce, invalid, I would say invalid, not fake, invalid divorce paper of 2014. Divorce paper of 2014, remarriage certificate of 2013, that was allowed. But I am the legally wed wife and I have been applying that my name should be recorded. And they have reprimanded the opposite party number 4 for not doing so. But they didn't enter my name.
You have entered name of other lady?
Yes, they have entered the name of the other lady.
But there is a marital dispute now.
Yes, that was not a marital dispute.
Why?
Because when I applied for this, I filed this writ petition, there was no information that...
That's all right. Afterwards, every information has come to you. There is a registration of marriage. There is a decree of the court.
There have been a history of marital dispute.
Question is, we are not rewriting the history. We are telling you.
Not required.
If there is a marriage registration certificate under the 1955 Act.
It's special marriage. Muslims, they're Muslims.
Special Marriage Act. They are married under Special Marriage Act. Then one certificate is issued. That itself constitutes marriage.
Yes.
The first lady, the other lady.
Other lady is that is the point, your lordship.
How you have to go for suit for justification of the marriage. You have to obtain a justification decree.
My lord, the inaction of the opposite party number 2 and 3 is evident because in the year 2008, I applied.
Not that when there is a merit dispute. There is a famous book by Radon on divorce. He mentions the suit for judiciation. Generally in India, the such suits are very rarely filed. A suit for judiciation is one where a decree is sought for to the effect that plaintiff is the legally wedded wife of the defendant, respondent, and the case may be in your state, I don't know. Defendant, what is different? Defendant. And the defendant number should be restrained from claiming to be the wife of defendant number 1.
Your lordship is absolutely correct.
Then
Now,
the
difficulty, your lordship, is that while adjudicating the matter, the honorable single judge has taken position on each fact leading to this marital dispute, and then gone on to say that these are factual disputes to which I do not wish to go. And yes, my lord, up to that point he was correct. And after taking position on each factual position, so that leaves the petitioner remediation.
No, we'll take the regardless of what is observed in the petition. Over.
Yes, my lord. Then second thing is that after taking these positions in each factual thing, he says that I will not interfere under 226 because there are factual issues involved. And then observing that, then he says that the petition is devoid of merit.
Correct. Therefore, he said, we will say that anything observed in this case will not come in the way of your instituting the civil proceedings.
That might help in proceeding the case, but what about the inaction of the opposite parties of 2 and 3, your lordship?
Unless you produce material to show that you are the legally wedded wife.
That is there, my lord. That has been produced.
No, because of the decree now. You will be out of everything.
There is no decree of divorce, your lordship.
No, registration. There is a registration certificate issued under the provisions of Special Marriage Act 1955.
In favor of other.
In favor of the other lady. The Supreme Court said the very certificate constitutes the marriage. There need not be this Saptapadi, this Nikah, etc. If it is Mohammedans there. There need not be Nikah at all. That very certificate constitutes the marriage between the parties. And the parties go out of the ambit of personal law. Once it is registered under the Special Act. Therefore, so many aspects are involved.
Kindly appreciate one particular factual detail, your lordship. In this case, the opposite party number 4 is an army officer, Air Force officer, who is regulated by the army regulations, which prohibits them to marry second time before obtaining a divorce.
That question arises if he agrees that you are the first wife.
My lord, that is agreed.
No, he alone cannot agree because another wife is there.
No, that is what I am saying. That other wife, the presence of other wife appears in the year 2013. My appearance is there, has been recorded in 2008, your lordship.
Dismissed, agreeing with the reasoning of the learned single judge. First, however, it is made clear that whatever observations have been made in the impugned order shall not come in the way of the appellant taking up appropriate legal proceedings as indicated by the learned single judge.
My lord, there is no indication, because he has taken positions.
Proceedings for establishment of her titled facts. Okay. This simple. Yes. Next is? What Delhi High Court? Which judge of the Delhi High Court had decided that?
My lords, Justice Chandradhari Singh, paragraph number 37, my lords.
Read.
The Honorable Supreme
Reiterated the Netram Yadav case, your lordship of the Supreme Court, where it was decided on the Disability Act and the Human Rights.
Yes, my lord.
Well, how that word preferably is interpreted by Delhi High Court?
My lords, here, if we
See the judgment. Let us see the judgment.
para 37.
You don't have 2 copies. You have 2 copies.
Yes, I have submitted.
It's here. Oh, is it? Huh? The speed of this you can take. I have another.
Now, just
2023 SEC online Delhi.
yes, my lords. My lords, I have submitted 2 copies.
37. Which paragraph?
37 number paragraph. The Honorable Supreme Court, Madam Apan.
Recently.
The Honorable Supreme
Paragraph 26 in 37.
26.
In 37, it quotes Supreme Court judgment, na?
The marginalization of the disability handicapped is a human right issue which has been the subject matter of deliberations and discussions all over the world. There is increasing global concern to ensure that the disabled are not sidelined on account of their disability. 27. A series of meetings, discussions and deliberations on the issue of human rights of persons with disabilities led to adoption by the General Assembly of the United Nations. Go
to 38 now.
Para 38 of this judgment. The Honorable Supreme Court held that the state shall ensure that the rights of the person with disabilities are being safeguarded by the state. Moreover, the Honorable Court held that the benefits box which are rendered to the persons with disability by way of any circular government order, the said benefit cannot be taken away from them by subjecting them to various terms and conditions, since the same would render such benefits of no use for the persons with disability. In view of the aforesaid discussion, it is concluded that the India, being a welfare state, embarks on ensuring that there is provision of equal opportunity to the persons with disabilities. Moreover, it aims at ensuring that the persons with disabilities are not subjected to any discrimination, either at place of education, place of work, any public place, etc., and further aims at ensuring of giving them access to the requisite education, training, medical facility, etc. And therefore, the state has enacted various laws.
That was in a different context. Now, that aspect is not considered. Word preferably is not occurring in that rule is not considered. It is your state rule.
Yes, in this judgment in paragraph 30 to 36, the Act, 2016 Act, it has been detailedly analyzed.
Correct.
It says why the Act is formulated, for what purpose has been formulated. Now, let me peruse the preamble of the rule.
No, I have read all this.
No, state government rule.
State government rule.
Yes, Millers. Which is at Miller's relevant page 25. The subject. Reservation and other concessions for the person with disability.
One second.
Yes.
Madam, is there any problem to accommodate him in the district?
Your Lordship, according to the Appellant's Counsel, the post in the Jashpur district has been filled up, and his home district is Puri, as per him.
Lordship
will pass an order that is a disabled
that
person.
we do. We just want to explore. It need not. We need not pass order in every case.
Yes,
Section 89 of CPC is applicable to writ proceedings now. Is it not? Because of judgment of
any
apex court.
It can be
By
in
conciliation
medical
also.
condition and medical.
We are telling you whether any post is available in Puri.
I have to take instruction.
You can just call and tell it. We'll pass over at 2 o'clock. We'll tell us. We to pass judgment in every case. When
Can it be tomorrow? Because I have to.
Yes,
go to the
again, why?
department.
Because we have agreed with you. Question of arguing arises when the judge does not agree. Yes.
Obliged, Your Lordship.
If the Honorable Court permits a small prayer, post available at Puri or any district adjacent or nearby to Puri,
So fair he is.
Yes,
Learned counsel for the petitioner having appellant.
Appellant.
Appellant having argued the matter now submits that his client would be satisfied if he is accommodated in the district of Puri or in any nearby place.
God is very clever.
First time. Learned AGA in this regard wants to confer with her officials and revert. We call tomorrow.
Oh, bless you.
Grateful.
Item 15.
Item 15, file has misplaced, lots can take up next week.
Next week. The request of learned DSC finally. Item 16.
There is delay of 15 days.
All right. What are the merits of matter?
Merits here, the recruitment of sub-inspector is under challenge on the ground that there is no...
Post-notice matter. It is post-notice matter. After notice matter. Notice.
No, my lord.
No, it is fresh matter.
Fresh matter.
Yes. Here the police recruitment, sub-inspector of police recruitment, they have put an advertisement for the same where they have kept reserved, given age relaxation of 5 years to the women, whereas their own recruitment rules does not permit it. Your Lordship, kindly have a glance to the advertisement, relevant part I am showing to your Lordship.
How long the recruitment was not undertaken?
Since
For how many years
2019.
it was not undertaken?
6 years. Since 2019.
years.
It is. Yes.
Correct. Therefore, they have given relaxation.
Relaxation to the...
Article 15(3).
No, your recruitment rule does not permit so.
Till we have held, which is that judgment, 2023, LIC of India versus so DB judgment affirmed by the apex court, which I have written.
Yes, that
Brother,
your
what
Lordship.
we have held is, understand this point now.
Yes.
We have understood your case.
Yes.
This is not case one. See, periodically the state has to undertake the recruitment drive.
Yes.
Because every year new candidates come to the market.
Your Lordship.
The other candidates will become age-bald.
Yes. Your Lordship is absolutely.
Therefore, where periodically recruitment process is not undertaken, and as a consequence, many people become age-bald, we have taken the view, it is the duty of the state to give age relaxation.
Lordship is absolutely
That
correct.
will not depend upon the authorization in the rules at all.
Yes. If your Lordship is correct, the same benefit has not been given to the appellants.
Then
They have
who
not-
It is
We
for
are-
you are
we are the men.
of women and children.
No, but 5 years, as your Lordship said, that they have not conducted the examination for 5 years. So the same 5 years age relaxation should be given to all the candidates who could not appear because of the age bar.
For women, they have given.
Only women they have given.
Yes, women are because they are a separate class who need.
No. 5 years, because not conducting the examination 5 years, the main candidates also become age barred. They could
That
not.
makes no sense because law differentiates between Mars and Venus. Men are from Mars, women are from Venus is a famous book. Law differentiates between men and women because Article 15(3) provides for that.
Your Lordship is correct, but they have come up with this notification, 19 June 2025. Kindly have a glance. My associate is there. You will just hand over to your Lordship that they have come this notification saying that this will not be applicable where the upper age limit has been specifically prescribed for uniform service like police, fire service, forest, excise service, and where physical efficiency test has been prescribed in the recruitment rules. Just B, Roman B, this last bottom of this notification, first page, they says, notwithstanding anything contained in any recruitment rule regulating the method of recruitment in civil service and or civil post in pensionable establishment under the state government,
the upper age limit for the entry into government service shall be 42 years, except where the upper age, Roman B I am reading, where the upper age limit has been specifically prescribed for uniform service like police, fire service, forest service, and exercise service, and or where physical efficiency test has been prescribed in the recruitment rules. So this age relaxation is not applicable to the police service.
Take notice. Issue emergent notice. Learned ASC is requested to accept notice for all.
No, 6 to your lordship may dispense with giving the notice to 6 to 16.
Whether you are from Delhi, you don't appear to be from Delhi by yourself. Are you from Cuttack or Delhi?
Yes, Cuttack.
Then why can't you come here so that we can save much of time?
Yes,
anyways, issue emergent notice. Yes, request the notice for 1 to 5. Emergent notice to the rest. Returnable within 4 weeks.
6 to 16 may be dispensed with. They are pro forma opposite parties. 6 to 16.
If you seek deletion, we delete. But if you seek on that ground pro forma
deletion, I pray for deletion of their names. Deletion.
Give one memo.
Yes.
Memo.
And short date may be fixed because the recruitment they are going to conduct the examination very soon.
Learned counsel for the appellant seeks leave of the court to delete respondent numbers 6 to 16 on the ground that they are only pro forma party person. Request is accorded, granted, and leave having been accorded is permitted to delete these respondents from array of parties at his risk.
What short date may be fixed?
Is for 1 to 5. Yeah.
Short date may be fixed because they are going to conduct the examination.
The matter after 3 weeks. Take this. Item 16. Hmm? 17. 17 is it wrong? Yes. Right. 18.
18, my lord, it is similar to item number 25 that Hemant Chotra, and this is in the board of today's.
25.
Yes, ma'am.
Yes, let us see 18. If there is, then we will apply 25 also to this.
Yes, ma'am. 25 is a bunch matter. It is to be argued addressed by that Hemant Chotra and Sarath Parida.
That has come before us now.
Yes, today's, my lord. It is in the today's board, my lord. Item 25.
Can hear all of them. Yes. 18 and 25 to be taken together now.
Together.
All right, start them.
No, my lord. They are bunch of matter. It has been assigned by.
Separately.
Yeah. Learned AG will address your lordship. Because
AG will come.
Yes, ma'am.
When your AG will come.
AG cannot come because he is on his legs before the Honorable CJ Court today. He is preoccupied. Because of that, he cannot turn up before your lordship. Otherwise, he could have been here.
Which date he will come?
My lord, your lordship will fix any Monday on 9th February.
Any day you take that day,
my lord, we have
to come.
My lord, we have strong objection. Since 1.5 years, this conventional argument is being pressed that the AG will argue, and in that ground, the time is being taken.
We are giving one date. If AG does not come, they will argue. We are not waiting for the AG.
Since 2000,
no, my AG's request is,
yes,
he is on the feet in the first court.
Well, you will
court.
You will have a glass of
one thing. But the PG on legs after lunch may not be
no.
appear at least. And it will
No, if suppose if he is the first.
That matter is likely to continue, my lord.
Continue for the whole day.
Continue for the whole day, my lord.
Mines.
Therefore, we'll have
It's a
it on
mining
9th of February. And the
Yes.
AG will come in the alternative. You have
Yes.
to be prepared.
Yes, my lord. Good.
Let it come week commencing 27th of January.
27th of January.
Yes.
No, we have posted many matters. Otherwise, we would have agreed with your proposal. We have put many matters in those dates.
Each month the teachers are retiring and they are dying also. Since last 2 years this matter is pending. That's why I am saying.
They are only seeking short
Last
date, my
2 years,
lord. Also.
not 1 day.
Yes, since
February
2020,
also approaching very short date.
This matter, along with serial number 25, to be called together on 9th of February 2026, as requested by Mr. Panda and Mr. Mohanty, learned EGS, on behalf of learned AG.
My lord.
First time. Call accordingly. First time. The AGs are put to warning that on that day, the request for adjournment from their side would not be entertained. Okay.
item 19.
Yes. Instead of one alarm. Yes. Next.
Like 19 is the matter wherein in person is there.
Jitendra Kumar Sahu. Call that matter. Call it.
Item 19.
Name.
Jitendra Kumar Sahu versus State of Odisha. Item 19, Jitendra Kumar Sahu versus State of Odisha.
Party in person is called out in the open court loudly. First time, there is no response. Call after 4 weeks. Yeah.
Item 20. Item 20.
Yes.
Item.
I order dated 9/1/26.
Yeah.
I was directed to serve copy of the petition, etc.
Now what should be done?
On behalf of the opposite party of 2 to 5. When I served the copy on the counsel appearing on behalf of the BSNL, he accepted the notice on behalf of opposite party of 2 to 4.
2 to 4.
2 to 4.
What is his name?
2 to 5 I will take instruction. I have also appeared, yes.
I have already panel counsel. Panel counsel. Shri so and so accept notice for
Here, Barik.
respondent numbers 2 to 6.
Barik.
No, petitioner, copy numbers 2 to 5. 2 to 5. 2 to 5. And who appears for 1? My lord. DSG, you appear for Shri. So and so appears for OP number 1, Union Government. Notice to OP number 6, tribunal is dispensed with.
Already dispensed with.
Dispensed with.
Yes, my lord, already order is there.
Is said to be dispensed with. Okay. Say, already said. Is already dispensed with. Okay.
Item 21.
No, they will not argue.
Not really. You don't want to argue. You want time.
This matter has been adjourned 8 weeks.
8 weeks.
Last occasion, this matter was adjourned to 8 weeks.
Now it has come again.
Yes, after 8 weeks.
Well, this matter relates to regularization.
How many years of service your client has put in? How many years? 8 weeks. So it comes after
8 weeks.
So we'll call it after 6 weeks now. All after 6 weeks.
Right.
Okay. All right.
Item 21.
21, my lord. in the other day, my lord says directed to take instruction and to file the affidavit whether this person, so far the post of driver is concerned, can he be accommodated in
any other post also.
on other post, my lord. My lord, I have taken the instruction and filed the affidavit, my lord, yesterday.
What they say?
My lord, in the meantime, my lord, so far this vehicle driver and since 99 as of now.
No, leave the vehicle. We don't want driver at all.
My lord, so far the appointment, my lord, has sought for the instruction that whether there is any appointment since 1992 onwards or not, any of the driver post.
Leave driver. Group D post.
My lord, Group C, Group D, it is by 2013 rules and which has been subsequently amended. By way of this advertisement, reservation, everything will be there, my lord.
But that question does not arise because you have suffered an order at the hands of the tribunal.
My lord, tribunal. But therein, when the panel was prepared, this present petitioner was found placed in serial number 3. There are 2 your post, my lord. That has been filled up.
They are driver's posts.
That driver post, that has been filled up.
Group D post.
Group D, that is the inconveniency. And as of now, the present petitioner is at the age of 55. So far, I am calculating the age, my lord. 52.
52. 8 years he will be serving.
So, in fact, there is the embargo. So far, this Rule 13 is...
There is an order of the court. Suppose if you are drawing from the market, you would have agreed. Now you are drawing from the order of the court, order of the tribunal.
But by that time, there are 2 posts for the your category. Out of 7 posts, 6 is to be filled up. And in fact, all of the posts have been filled up. And the present petitioner belongs to category of your and serial number 3 in the process of selection. 2 of them has been filled up.
But what do we say about the order of the tribunal? Rightly or wrongly, there is an order which has attained finality. What is the order you have challenged here now?
Order of the tribunal.
That very same order.
No, sir.
Different order.
Annexure 8, page 18, while they stated that in compliance affidavit that there is driver post available, but this is no vehicle.
No vehicle.
No vehicle for that reason. They have been. And
you went on changing the stand, Mr. Mohanty. Other day, G was appearing. You means you are nice. First, they say all posts are abolished. Then we asked them which date they are abolished. They said they have been abolished in the year 2007. I remember because myself and brother heard that matter. And then you said there are no posts yet.
And no
vehicles. No vehicles was there. They should have said we have no vehicles, though there are posts. We found out no post is abolished. There is no abolition order at all.
Well, so far the vehicle part is concerned.
Vehicles are
since 2015. It is in outsource.
Vehicle is not available is one thing. Post is not available is another.
But no recruitment has been made since
that we do not
99 million.
Correct. But there are posts.
And the existing persons, those who are working since long, they are continuing until their retirement. But no fresh engagement has ever been made since 1999.
What is the order now of the tribunal which you are challenged now?
Page 18.
1-8.
Order. From the compliance report, may I read, madam?
It was a content matter.
This is arising out of the OA, which is at page 14.
CP means what?
CP means content
petition.
Arising out of the OA.
Arising out of the OA.
Since that original application has not been completed, content is pending. Last 2 para.
The operating part of OA, it will be clarified.
This is sanction post of driver. 24 drivers are in position, but as no other government vehicle is available, the collector Sambalpur is not in a position to issue order of posting in favor of the applicant. From the above compliance report, it appears that no order of posting could be issued as no vehicle was available.
You have put in challenge this order of the tribunal.
My lord. And the
While the contribution has dropped,
See, if any vacancy arises, kindly come to Mr. Mohanty.
Yes, ma'am.
Kindly come to page number 19.
19.
Yes.
As the respondent authority
Yes.
have filed compliance report showing impediment for which the applicant could not be issued with the posting order. The order of the tribunal.
Therefore, CP is dropped.
Yes.
Next line.
However, it is left open to the state respondent to consider posting of this applicant if the vacancies arises in future. The applicant is also liberty to agitate the matter if there existence of any fresh cause of action. My lord, we have excluded.
Again, he should go to CAT. Whole life he has to be in the agitation.
My humble submission would be, the opposite party has explored the possibility if at all there is any vacancy before the CDMO or any other authority under the domain of this collector. And practically it was not possible because of non-availability, because there was no such recruitment since 99 onwards.
No, question is not that. Order is, it is left open to the state respondents to consider posting of the applicant. You have to post him there.
However, it is left open, my lord.
Left open.
So we have explored the possibilities so far the availability post and
this order appears to be wrong order. The tribunal could not have dropped the proceedings because the
one way it has been dropped in one, and another way it is however left open to the state.
No, that is worsening the it is killing its own order. The tribunal is upsetting in contempt jurisdiction its order in the original jurisdiction. It could not have done that. It has swallowed the order. The tribunal by the second order has followed the first order. That it cannot do. Because in the earlier order, see, though it is very loosely crafted and drafted, but we understand the intent of the tribunal, that he should be given a post.
There in the language it is expected.
See, therefore we, perhaps the judge of the tribunal has never read any book on art of writing judgment at all. Not even single book he has read. They expected dangerous words there. In the operative portion of the order, they should not appear. Though in the judgment portion, we can understand. Operative portion should be clear cut.
or else implementation.
Who should do what within what time, how. Over. That is not there. But that does not come to your aid. Well, our orders, we are not at the mercy of the grammarians.
But my lord, in pursuance to your lordship's observation, in earlier occasions also explore the possibility. So far this appointment in any other post, so far the adjustment is concerned.
Then we will set aside this order and issue contempt ourselves.
And my lord, subsequently, so far this 2013 Group B, Group C.
The concession shown to you. That was concession shown to you because immediately we did not want to take penal action against your officers. Because the order of the tribunal is wrong. And saying that order of the tribunal is wrong and go before the tribunal again is meaningless because he cannot go before the tribunal. Now, rightly or wrongly, there is an order. Whatever order the tribunal could have passed, that order a writ court can pass. The power of the writ court is coextensive with power of the authority whose proceedings are called in question.
Yes, ma'am.
Therefore, what order tribunal should have made, we will make that order. We had given only concession, 4 or 5 times you had taken time.
But fact remains, my lord, it is a recruitment process of 98-99 million.
Correct, but there is an order, rightly or wrongly. It may be a wrong order. You have not challenged that order. You took defense against the order without challenging that order. You took defense, which we find is a hollow, not sustainable defense.
And the petitioner has filed this writ application.
Correct, writ petition. Because he is aggrieved by the order of the tribunal. Order of the tribunal is substandard. As substandard as can be.
Therein also contempt was dropped. But however, this order has been passed. And taking into consideration that aspect.
Challenging.
That is how.
What he says is, when there is a direction you have not followed it, Then saying that it is open to you, that we are not in the Ram Rajya. We are not in Ram Rajya, that things will be done as Lord Rama would have done had he been today here.
Now he became over-aged, my lord. Availability post is in question.
That question will pale into insignificance because aging, there cannot be stay against aging. Everybody will suffer aging. How can you take the benefit of aging?
This is aging is inevitable, my lord.
Inevitable. It happens. No court can give stay against aging.
And again in Group D also. You are only saying about Group C.
Group D also.
Yes.
It is guided by 2013 rules, my lord.
We are answering you. That question will not arise because you are in the teeth of the order. You are in the teeth of an order passed in a proceeding to which you were a party and you were heard. Then the order has been made. Aging happened because you did not implement the order.
And
How
this,
can you take the benefit of
this order is of 2017.
Maybe you never challenged it and you are simply
because this tribunal order was dropped.
Therefore he is here. We will impose heavy costs, set aside this order, and we will impose heavy costs on your rights.
Lord, my affidavit may kindly be considered.
No, question is not that. Question
Because of the
is,
practical inconveniency, literary meaning is something, my lord. So for the appointment or absorption of this particular person,
then pay rupees 5 lakh to him.
and at this age, my lord, and particularly since 2000.
Therefore, we will relieve you. We will impose cost of rupees 5 lakh, give 5 lakh rupees to him. We have that power to give lesser benefit also.
I don't have any doubt or questioning your lordship's power in 26, 27.
No, not that.
I am submitting, my lord, with all humiliation so far the grant.
Not necessarily. You need not be humble at all. You can be very arrogant with us so that you can make good orders.
The wrong of the court.
Question is, there is an order. Now it cannot be implemented because aging has taken place. That aging would take place because of your mistake. Had you implemented the order, this contention would not have come to your aid at all. Now things have happened. Whatever is happened is happened. Now we direct you to pay a compensation of rupees 5 lakh to him so that he can live with that money.
Even, my lord, after dropping of the contempt also, we have explored the possibilities, my lord.
That makes no sense. It is not possible according to you. We agree with that now. Therefore, alternatively, we have to do something. We will direct 5 lakh rupees. It may become a bad precedent for you in rest of the matters.
Yes.
This is a new invention. Amartya Sen, in his idea of justice, which he wrote in variance with his guru's book, John Rawls' book, A Theory of Justice, he suggests where order cannot be implementable in its true spirit, then the courts can find out secondary reliefs.
The
alternative, something like alternative.
My humble son, since 1980, and no also junior persons have ever been appointed in the meantime also.
In any case, this order has to be set at rest or not? Or you go on
for the latches of the court, these persons.
Thank you.
Government with the wrong of the court.
Aggrieved citizen is knocking at the doors of Great Court for assailing State Administrative Tribunal's order dated what?
5/9/2002.
5/9/2002. No.
Say,
which order is under challenge?
The contempt dropping order is under challenge.
Contempt dropping order is 22/11/2017,
whereby the contempt proceedings in his CP number 38 of 2003 for implementing the order dated
22/11. Oh, the order dated earlier.
Earlier order is dated?
It is 9/2002.
Annexure 5, page 14.
5-9.
5-9,
That is 5/9/2002.
5/9/2002 entered in his OA number 1700 of 2002 has been negative, have been dropped. First term. Next paragraph. One sentence you can write. The operative portion of the said order, 2017 order, reads as that. Next paragraph. Learned counsel for the cited. Learned counsel for the petitioner vehemently argues that rightly or wrongly, his OA number 1700 of 2002 having been favored, while the order dated 5/9/2002, the benefit of that order should reach the hands of his client. Seven. The efforts made by the petitioner by filing the subject content petition number, CP number, contempt proceeding
38
of 2000, CP number 38 of 2017.
2003, Milord. 2003.
CP also 2003. CP of 2003.
Disposed of on 2017.
Have not yielded any benefit. And on the contrary, the tribunal took about 15 years, correct? 15 years in for passing another erroneous order, which is put in challenge in this petition. First off, he submits that the rule of law is upheld only when the party victorious in the legal battle reaps the fruits of victory and not otherwise. First off. So arguing, he seeks for voiding of the impugned order and further passing of a punitive order against the respondent's hearing, OP's hearing. First time. Next paragraph. Learned AGA Mr. Mohanty, appearing for the OPs, resists the petition, contending that the order dated 2002 order, which is that?
Yes.
With OA was allowed, na? Give that date.
2002, 5/9.
5/9/2002. Why not 5/9/2002? 5/9/2002. Passed in OA number 1700 of 2002 does not contain any enforceable mandate as such. It is more in the nature of recommendation, and therefore the tribunal has rightly dropped the contempt proceedings. First, he also adds that all efforts were made to accommodate the petitioner in the post of driver and also in other group depots. However, the efforts did not bear any fruit, the driver posts not having been filled up for want of requisite number of vehicles, and the vehicles being outsourced.
By virtue of that, since 2015.
Since 2015. Our question is, up to 2015, all they were available. Why did you not accommodate is the question?
For a moment, there was an advertisement in 1999. They have appeared for the same. There are 7 posts. This particular person belongs to your category.
That contention you have taken up and that was rejected by the tribunal.
But they have not given this because 2 persons have been appointed. Absolutely, there is no problem. This person is found place in serial number 3. For that purpose.
No, all these contentions, either you had taken up before the tribunal for resisting the way, or you are deemed to have taken up them by virtue of constructive res judicata. Those are not available to you. You cannot take up a contention to rescind the original order dated 5/9/2002.
No, there we have also taken.
Therefore, those are now not available.
The electric house is prepared category wise and the applicant is found place in serial number 14 in the list.
So it is considered as you have not challenged.
Sir, they have already given appointment order to annexure 2, but since vehicle was not there, the annexure 2 page 9 kindly perused.
Annexure 2 appointment order was given to you.
But collector has given to go on appointment, issue appointment order to the assistant town planner. But he did not, since the vehicle was not there, so the appointment order was not issued by the assistant town planner. Collector has already issued in favor of me. Repeatedly they are saying that 2 post.
Oh, in his contention. Counsel draws attention of the court to collector's order letter dated
18/2/99.
26/3/1999
to assistant town
annexure 2, wherein he had asked the assistant town planner to appoint petitioner as a driver, and further to mark the letter of appointment to the office of the district employment exchange, in addition to collector's office. First, that we have to do. Next.
Next annexure 3 kindly peruse, my lord, also. Since the assistant town planner vehicle was not there, immediately collector asked CDMO to disengage the temporary driver from your office and issue appointment order in favor of the petitioner also.
He also draws our attention to who is the CDMO means?
Chief District Medical Officer.
It is an internal communication of the
CDMO's letter, sorry, district, additional district, ADM's letter dated 7/7/1999 addressed to CDMO to disengage the temporary drivers they were serving on daily wage basis, if any, and to report category wise vacancy for sponsoring names from the panel of drivers maintained in the office. First off, in the light of this, he submits that there is gross violation of the original order of the tribunal, and therefore the contempt proceedings could not have been dropped. Next paragraph.
Well, it is of 99. Order is of 2002.
Thereafter,
contempt is thereafter much. It is much prior to that.
Correct.
Because it is of 2017 contempt.
Correct.
So far, the challenging.
No, before original order was passed, these documents were there.
Yes. Well, that was a need-based failure, possibly. as it is rebuilt from this annexer, my lord. But the challenging order is of 2002, my lord.
Mr. Monti submits that the letters at annexers 2 and 3 would not come to the aid of petitioner in as much as they precede passing of the original order dated 5/9/2002, whose implementation has been sought for. First off, so contending, he seeks dismissal of the writ petition. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited indulgence as under and for the following reasons. Number one, the tribunal wide order dated 5/9/2002 had disposed of petitioner's OA number 1700 of 2002. First off, the operative portion of the said order reads as under. You put that operative portion, where it is put on that portion. All right. Next paragraph. Sentence in that paragraph. This order was sought to be implemented by instituting CP number
38, my lord, 2003.
CP number 38 of 2003. First off, the tribunal, instead of enforcing the said order, has dropped the contempt proceeding with the following observations. That entire order is to that operative portion. Follow observations that after in the operative portion. First, next paragraph. We fail to understand as to how the tribunal could have dismissed the CP and thereby dropped the contempt proceedings when the order dated 5/9/2002 was not complied with in letter and spirit at all. First off, the litigants come to courts and tribunals not for just getting some order, howsoever they are texted, but they knock at our doors to get justice. Justice. First of all, no court can say that its order is unenforceable when subject to all just exceptions into which case of the petitioner does not fit. First of all, there is an order, though not happily worded, made by the tribunal on 5/9/2002 by allowing petitioner's OA number 1700 of 2002. First of all, it was the bounden duty of the tribunal to enforce this order either by contempt proceedings or otherwise. First of all, if it is not enforceable, if it was not enforceable because of changed circumstances like the candidate turning age-bald or the like, then secondary relief ought to have been granted to the citizen by way of compensation, stroke damages. First of all, this accords with the view of Amartya Sen expressed in his idea of justice, for which he secured Nobel Prize. First of all, this exercise has not been done by the tribunal while simply dropping the contempt proceedings as if its hands are tied and nothing could be done in the matter. First of all, next paragraph. Learned AGA, kindly be seated. It disturbs me if you stand up. I cannot sit if you stand up. That enough. Learned AGA, Mr. Mohanty, draws our attention to the affidavit filed in the matter, essentially to the effect that the posts of drivers are not available for being filled up. Semicolon. There is no other Group D, C or Group D post in which petitioner can be accommodated. First one.
Well, one point. Since 99 to till date also, none of the person nor any junior persons have ever been appointed.
The question is whether ever anybody has retired, anybody is dead, anybody has resigned, anybody is removed. That you are not answering. Even
Thereafter, no recruitment was made.
You are answered, not point. We are asking you
after retirement of
people retire or removed, resigned. Is it not?
These eventualities have taken place or not?
That you are not mentioning.
That eventually has taken place.
Taken place. You have not mentioned despite your undertaking.
No recruitment was made because since 2005
vacancies are available.
Yes, ma'am.
Vacancies are available.
But by the process of outsourcing of the vehicle, this could not have been possible for the authority since 2015.
Accommodated. First off, he also vehemently submits that that since 1999, no recruitment process has been undertaken. First off, however, nowhere in the affidavit it is mentioned as to how many vacancies have accrued after the passing of order dated 5/9/2002 till date. First one, men being mortal die away and vacancies accrue. First one, employees are removed and vacancies are accrued. Employees retire since employment is not for life peerage and therefore vacancies would arise. Employees are removed and eventually the vacancies would arise. The affidavit filed does not mention anything about the accrual of vacancies with full particulars. First off, what came in the way of giving effect to order dated 5/9/2002 till 2015, remains a mystery wrapped in enigma. First off, that would not augur well to the adjudicatory process wherein state is the stakeholder. First, next point. The last contention of Mr. Mohanty that the petitioner is now overaged and therefore he cannot stake his claim for regular recruitment again is difficult to countenance. First off, the petitioner was not overaged when the order dated 5/9/2002 was passed in OA number 1700 of 2002 after hearing the state and its officials. First off, it is they who brooked delay of all these days without caring to implement the said order. First off, after all, petitioner is not staking claim for appointment as the district collector. First off, what he wanted was a simple post of Group C or D categories. First off, we do not agree with the contention of Mr. Mohanty that no appointment would be given to the petitioner in terms of order dated 5/9/2002 as the driver, in as much as all vehicles are outsourced. First off, it is because the force of drivers are not abolished. First off, maybe for economic or administrative reasons, they have outsourced the vehicles. First off, as long as the posts remain, so long the obligation to comply with the order dated 5/9/2002 would continue. First off, anything contrary would undermine the rule of law because it gives scope for flouting the orders of court and tribunals. First off. Next paragraph. Be the above as it may. First off, much water has flowed under the bridges and long time has lapsed after the making of the tribunal's order dated 5/9/2002 in petitioner's OA number 1700 of 2002. First off, the order remains unimplemented with no justification whatsoever. First off, such a non-compliance of the order would not have gone with impunity when the petitioner had filed a CP 38 of 2003. First off, for any reason whatsoever, if the order of the tribunal is not implementable for reasons not attributable to victorious party in the litigation, nothing prevented the tribunal from granting some damages by way of recompense. First one, that effort also is not made, and thus there is an error apparent on the face of the record. There is additional error apparent on the face of the record. First one, justice of the case warrants that a reasonable amount should be paid to the petitioner for the agony that he has been put to because of non-implementation of tribunal's order dated 5/9/2002. First off, it is more so because tribunal's order dated 17/9/2017 passed in CP 38 of 2003.
22/11/2017. Page 18.
Passed in CP 38 of 2003. Instead of granting relief to the petitioner in terms of its order dated 5/9/2002, entered in OA number 17002 of 2002, has swallowed the order itself. First off, this is a bit difficult to countenance. First off, in our considered view, a sum of rupees 5 lakh, a lump sum of rupees 5 lakh paid by the respondents, to be paid by the if paid by the respondent, would meet ends of justice. First, in the above circumstances, this petition succeeds. although the impugned order is sustained in the changed circumstances beyond the control of parties, petitioner, the respondents together are directed to pay a sum of rupees 5 lakhs, lump sum of rupees 5 lakh to the petitioner by way of damages. Within a period of 4 weeks, failing which the amount shall carry a cost of rupees 500 per day for the first 30 days and rupees 1,000 for the days next following. First, this amount may be recovered from the erring officials in accordance with law. Okay. Yes, sir.
And the next item may
You want time in that?
My lord, on behalf of the family member has died.
In that case, I am for the appellant.
Can you give the time?
Yeah.
Call in the second week of February.
Cash me, Lord. Bank officer, lady, permanent bank.
We'll have it in second week of February. Next week we have difficulty. Second week of February we have. Send the request of so and so, and with the consent of counsel for the appellant. Okay.
I may be pardoned, my lord. So make a mention item number 33, my lord. I am for the item number 33, my lord. I am for the petitioners. That's my learned senior is
opposite party. Do you agree with the proposal?
Lord's pleadings are complete. Only a convenience chart has to be placed before.
What you want?
A time, my lords. A time.
You will give time. You need not say that you want to marry. Yeah. Call in the third week of February 2026 at the request of so and so and with the consent of so and so. Okay. Yes. Passover item number 5. Item number 5. So none appears. Call in the third week of
This is item number 5. He was there. Later on, he came and
later on he came and submitted that.
I mean, we have given account.
Okay. Order we have passed. Just. Yes. Item number 22.
22, my lord. The appeal by the state as well as the private parties, my lord. It has analogously. Because G has been interested, but because of the, I pray for 1 week time, my lord.
My lord,
2 weeks at the request of.
My lord, throughout of my service career, my lord, limitless harassment has been caused to me.
Next date you can argue that.
It is this.
We'll have it in the third week of.
And my lord,
February.
so I'm pending, my lord, because of since 19, my lord, they are taking time due to bulky.
Not the 19, 2024 appeal, na?
No, it is a 19.
19 appeal. Serial number?
22.
Serial number 22, read me lord.
And it's here against the order of the OIT.
And call in the third week of February 2026, finally, at the request of Learned AG, who assures that he will not seek time anymore. Yes. Item number 23.
And item number 23 is maybe called next week or any date convenient.
I am appealing for the opposite party workman. Yes. Do you oppose the proposal? Yes, Lordship, because the award of the Mr. Tribunal was appealed by the High Court. The writ application, the computation was made by the Labour Court, and basically the benefits are required to be paid, and some part benefits were paid to the opposite party workmen, and the rest amounts are withheld. So, if my learned senior is praying for a time, I pray for a short adjournment be given. And previously also, the writ application also dismissed for non-prosecution. 2 weeks at the request of. Yes.
Any date after 10 minutes. I'll not be available till 10 minutes.
Therefore, after 2 weeks.
Deeply. If you're not so to date, that will be better minutes. I don't want to delay the matter.
Let us see.
Item number 24.
My lord, this is an appeal by the state where delay is also there, my lord.
My lord, on behalf of Mr. Mishra, kindly pass over.
156 days delays. 156.
156 days. Post notice it is. After notice matter.
Yes, my lord. No.
For admission it has come.
Yes, for admission it has come. They have filed perhaps objection to that, my lord.
No, your brother wants Passover. He said Passover will have it after 2 weeks. Yes.
Item number 26.
Mention, I am representing for appellate in the writ appeal 5.
I am for the respondent. Yes.
So, my humble submission is that
yes,
writ appeal is derived from the judgment which is passed on the writ petition 26972 of 2023. This application is derived due to the Honorable Court in the writ application pass a judgment and give the direction to the opposite university to conduct the exam and and publish the result. Now, which is not possible because one thing is that the respondent didn't attend a single class. He joined in a regular course, a full-time LLM in postgraduation department of Utkal University from 2010 to 2012, the 2 academic years. He completed the first semester class. He completed the second semester class. He completed the third semester class. And he also appeared the first semester exam and second semester exam. Fact is that in 9/1/2012, he joined in the government post in a judicial service. So in respect to that, he is not able to appear the regular exam of the third semester, and he get the permission from the higher authority to appear the back paper of the third semester. When it arises that to fill up the form for the fourth semester, the exam, the university didn't allow him because he didn't attend a single class. Attendance is 0. Now why? Now first thing, according to this act, the students should be attend minimum 75% the class attendance, total attendance. In case of the sportsman or other things. So there is a chance of up to 65%. But in other ground, when a particular student didn't attend a single class, how they are allowed to for the exam? That is the first point. And the second point, yes, sir.
What the learned single judge said on this point?
So he considered what they mentioned a delay. And in respect to the delay, and he allowed him to for the exam and the delay. What is the meaning of a delay here? According to the petitioner, and here the respondent submit that in the court that the court's academic session was started in delay. It is totally not acceptable. When he attended the first semester class, it didn't arise.
Yes. Just hold on 1 second. Yes. appearing in the classes.
My lord.
You have permission.
Your lordship, everything has been discussed by the
I
Lord
do
single
not
judge,
know.
my lord.
We are asking a question to you.
My lord.
You should understand the question.
My lord.
Try to answer it.
My lord.
Whether your client had permission from the High Court
My lord.
to take up classes.
Yes.
To appear in the class.
Yes.
Where is that?
That thing has been, my lord, paragraph 35, page 38 of the judgment.
Impugned order is in challenge. We cannot look into that.
My lord.
Independently, you have to show.
My lord, because earlier writ application, 2 writ applications were
Mr.
filed.
Tripathi, the question is very clear.
My
The query is that whether the incumbent was allowed or permitted to appear in examination or also to attend the class.
Yes, annexure 2 of the writ application, my lord.
Read.
Annexure 2, page 19 of the writ application.
Page number?
Page 19.
This is the first title.
No, this is not that.
This is
This is in the writ application.
Read.
Writ application. Because direction, your lordship may kindly see, permission in favor of.
To in read application.
Yes, page 19, annexure 2 of my writ application. Permission in favor of C. So-and-so civil judge on probation Cuttack to appear in the final year LLM examination.
It is examination. When is the classes? Permission to appear for the classes.
My lord, permission is that has been discussed in the judgment, my lord.
Therefore, it is put in challenge now.
No, my lord. That is, I want to read 1-2 paragraph of the judgment, my lord. Thereafter, I will answer my lord's query, my lord. Because with regard to the grounds raised by the learned counsel for opposite party university that there is an embargo in the regulation with regard to the number of years within which course is to be concluded. That is in the present case 5 years. This court observes that such an embargo contained in the regulation could not be applied to the fact of the petitioner case, in as much as petitioner had approached this court in the year 2013 immediately by filing WPC number 18381 of 2013, which was disposed of on 22nd August 2013. Thereafter, by filing WPC number 18022 of 2016, which were disposed of. My lord, I am reading. Thereafter, due to non-compliance of the order dated so-and-so, filing contempt number so-and-so, which were disposed of on perusal of the aforesaid writ petition, this court observes that the petitioner had challenged the inaction of opposite party university in taking a decision in respect of present petitioner. Therefore, the opposite parties are stopped to take a resort to the aforesaid regulation imposing the 5 years restriction, as the delay in conclusion of the course by the petitioner is solely attributable to the opposite parties. For opposite parties, it was delayed. For university, and the
Now, what is how we want to know how many is it trimester or a semester system here?
Semester.
Semester system, sir.
All. How many semesters this course will continue?
So 6 semesters. 6 semesters.
And my lord, all the semester. Sorry.
How many semesters he participated in the classes?
Sir?
In the classes. How many semesters? How many classes he attended?
He didn't attend a single class, sir. 0 class. I'm talking about the 4th semester. He didn't attend a single class because he joined the regular service.
Mr. Acharya, in the entire semester,
Yes, sir.
how many classes he has attended in other semesters also?
Sir, he joined in all the classes according to their information. Just now I have no information. Though they allow for the first semester, second semester, third semester examination, it means that he attained above 65 or 75% of the class. It's applicable to sir everyone, sir.
Why, Mr. Acharya? Continue. Why? See, there is so much communication gap between bar and the bench in this matter. Because you are online. If you are
Sorry, sir. Due to my health problem, I'm not able to reach. You fix another date, I will go court. Due to winter season and asthmatic problem, I'm not able to. Sorry for virtually I'm present here. Okay.
Which
I'm
date,
sorry, sir.
Acharya, which date will be convenient to you?
Sir, humble submission, you fix any date after February, first week or second week. I'll be there, sir.
On the second week of February. 2020.
Sorry, sir, I virtually am appearing. Sorry, sir.
No, what happens, sir? See, you will say something.
Okay.
You will say something. There is two monologues do not make a dialogue.
Okay.
Two monologues. Your monologue, our monologue, do not make dialogue.
Yes.
Therefore, we request wherever possible, if the location okay, they can come and argue.
Oh, sir,
But
sir.
for away, Delhi, etc., no problem.
My lord, may
We will
kindly
argue and we will do whatever we will.
My lord, may kindly see order dated
After that.
yes 8/4/2024.
Next.
This honorable court
28.
My lord, result may be published. I have appeared in the examination. Result not published.
No, 2 weeks we will take up the matter itself.
My lord.
Item
Yeah.
28.
28. This is arising out of
Yeah.
Yes. Milord, the order impugned passed by the Honorable Single Judge under the provisions of Odisha Land Reforms Act is assailed before your lordship.
Land Reforms Act.
Milord, under the Land Reforms Act, there is a ceiling limit, Milord. A family can hold land to a ceiling as described, that is up to 10 standard acres.
10 standard acres.
Milord.
Suppose all irrigated, not.
No. There is a classification. Milord, there are four categories of land: class 1, class 2, class 3, class 4.
This land is in which category?
Milord, it is class 4 category.
Class 4 category.
Milord.
Class 4 category generally is larger extent.
Yes, it is up to 36 some odd acres.
Okay.
Milord, initially 3 ceiling cases were started. They computed the ceiling surplus area.
Just give us a gist of the case so that we can focus to other provisions of law in the light of that gist. What is the gist of the case?
Milord, I am just making the summation, the gist of the case. Since our family is a large family, Milord, it was holding 267 acres of non-irrigated land.
That the class 4 land.
Class 4 land.
264 acres.
Milord. District of
Family comprises of how many members?
Milord, I have given a genealogy, Lordship, that is a large family, Milord. At page 38, I have given a genealogy, Milord.
Yes.
38 of the writ petition,
Yeah.
the writ approved. That is.
Then what happened?
Milord, initially 3.
If excess land is held by the farmer,
Yes, Milord.
what should he do?
They will
surrender the land?
Yes, Milord.
There are provisions for surrender.
Yes. So, under the provisions of Odisha Land Reforms Act, a proceeding, ceiling proceeding is required to be initiated. The initiation by either party. The persons holding the ceiling surplus land may file a return
saying that I have got so
these are the land out of which I want to return this much. And this much land may be surrendered.
Whether has he any choice that this land, particular land, I want to retain this. There is
under the act, the choice is the landholder. So the other mode of initiation is the Tahsildar, who is the revenue officer, is to initiate a so mode of proceeding that you are a ceiling surplus landholder. File your return. File your return. Indicating how
many acres of land he is
indicating which land you want.
He is entitled to retain.
Yes, indicating your choice, which land you want to return. Here, the Tahsildar initiated 3 sealing cases.
Which is
against
that
our
section?
three
Which section?
under section 40 your lordship. Milord, it is submission of return is 40A.
Section 40 capital A.
Capital A of the OLR Act.
The ceiling limit is which section?
Sir, determination is section 39. But initiation is
No, ceiling.
Ceiling, yes.
Which section?
That is
It must be separate section, na?
Milord.
Let it schedule.
Milord, under the OLR Act,
Yeah.
the 37 is the Milord. Lordship, may kindly have a glance.
Tell them to give the book. What are they doing? Give the book. Land Reforms Act. Court officers should be alert to what is happening in the courthouse.
Selling and disposal of surplus.
37.
Milord, it starts from 37.
Person includes company, family. Right. So family in relation to an individual means individual, husband, wife. Husband or wife.
Husband or wife, as the case may be, of such
major
individual
married
and their children, whether major or minor, but does not include a major married son.
Before the 26th day of September. The 26th day of September, 70 is the cutoff date.
That was the date in which this chapter was initiated.
Therefore, they have put that date.
Yes, Milord. Yes, Milord. So 3 sealing cases were initiated against our family.
Now let us see that the provisions. Let us see the charging provisions.
Milord.
How they run. Then we can understand.
Then your lordship may kindly see 37A.
36 declared.
36 is the declaration of a royalty, non-redeemable tenant.
37.
37A, then your lordship may see. Sealing area has been defined.
This is with effect from 1970, September 70.
Yes, Milord.
Person includes company, family, association, or other body of individuals, whether incorporated or not, any institution capable of owning or holding property. Then family in relation to an individual, husband, wife, and major children who were not separated as on 26 September. It should be
absolutely correct. So it only excludes the major separated son on and from 26th day of September 1970.
Before the 26th day of September, he should have been separated before.
Before.
Then he cannot be included.
Yes, that is a separate for each married and separate son. Prior to 26th day of September 17, there can be separate sealing proceeding.
No. Family will include
Milord.
Husband or wife.
Milord.
Then the son who resides with the family,
right, Milord,
till 26th of September.
Absolutely
1970.
Son, major, and married. Not.
The son is a son.
No, here there is a distinction.
Is it?
Yes, yes. So, Lordship may kindly see. Husband or wife, as the case may be, of such individual and their children, whether major or minor.
Correct.
But does not.
Major or minor, comma. So this is a disjunct, yes.
Milord.
But does not include a major married son.
Yes. Who had separated?
Who as such had separated.
Yes.
Had.
So that means there is a distinction between a major married son living with the family without being separated
and unmarried major son with the family.
Yes. But major married son separated.
Or otherwise, yes.
Yes.
Or otherwise.
Yes.
What is that otherwise? Partition we can understand. Maybe it may be like family arrangement, something like that.
Right, Milord. But it has got no application so far this case is concerned here. Because it has carried to the revision. Revision has said that 4 sealing cases are to be initiated, not 3.
Yes.
Now, your lordship may kindly turn to section 37A, ceiling area. As your lordships are using the question. The ceiling area in respect of a person shall be 10 standard acres.
37A.
37A.
Area in respect of a person shall be 10 standard acres, provided that where the person has family consisting of more than 5 members.
Miller. The ceiling area in respect of person shall be 10 standard acres, increased by 2 standard acres. For each
standard acres. Means 12 acres.
Miller. In respect of each member in excess of
member in the family.
Family in excess of 5. Suppose there are 7 Miller, there can be 10 plus 2 plus 2.
So in excess of 5, with the number 2 standard acre more.
More for each member.
Each member.
Exceeding 5.
Exceeding 5.
Right.
That means 12 acres.
12 acres if there are 6.
Correct.
14 acres if there are 7.
7.
Likewise, Miller. Then your lordship will 38 is the exemption from the ceiling.
But again there is a cap. The ceiling area shall not exceed 18 standard acres.
Right.
Regardless of number, suppose if the family comprises like Kauravas, 101.
Miller.
Then in such cases,
it cannot exceed.
Only relevant, the ceiling limit is to the number also.
Yes. So in no case it can exceed 18 standard acres, even if the family exceeds more than the number prescribed.
Maximum number of the joint family will be 9. 9. That means 18 acres.
Yes, Miller. If it exceeds 9 Miller,
then no question.
No question of giving more.
Yes, got the point.
Miller, here, 38 is the exemption. 39 principle for determining the ceiling area.
On and from the commencement of this so and so, no person shall either as landholder or right or as both be entitled to hold any land in excess of the ceiling area. This is an all lands held individually by the members of family, joint family by some or all of them shall be deemed to be held by the family. This only disentitles that person to hold excess land.
Absolutely.
That's all.
Miller. So, 38 is exemption from ceiling area.
37B. 38 is exemption.
Miller.
That may not be applicable to your case.
Miller,
you are pressing into service that section.
Miller, 38 will be applicable. I will take your lordship to 38.
Read 38. We will understand what is that.
So as otherwise provided in this section, the provision of this chapter shall not apply to lands held by a privileged owner are not concerned.
1 second. Otherwise provided in this section, the provisions of this chapter, that means whole chapter is
not applicable if he is a privileged owner. Privileged owner has been defined under this statute.
Who is he?
Miller DT.
DT. Like Lord Jagannath Maharaj.
Once you ask the question, your Lordship may come to the definition chapter, privileged owner has been defined.
Section 2.
2. Miller section 2.
Subsection
24.
24. You are right. No, 24. 24. You are right.
Miller.
Cooperative society.
6 categories of person.
Land Development Bank. State Land Development Bank. Lord Jagannath. Any trust or other institution declared under this act to have been privileged right. Any trust or institution whose estate has been declared to be a trust estate.
Any other trust?
Any other trust which is declared to be a religious or charitable trust of public nature by the tribunal constituted under section 57 capital A. Any public financial institution.
These 6 categories of persons are privileged.
But anyway, you are not a privileged.
Not a privileged.
So lands held by a privileged right is not applicable to you.
No, Miller.
So proviso is also not applicable. B.
Miller.
Lands held by industrial or commercial undertaking, whether it is applicable?
Not applicable.
Not applicable.
Miller.
So proviso is also not applicable.
Miller.
Second provision is also not applicable to you. C, plantations.
No, also
applicable.
not come.
Then D, lands held by any
It is also not
university, agricultural school or college, or any institution conducting research in agriculture.
It is not applicable.
Then section 38 itself is not
applicable.
But you said it is, you want to take benefit of
That's
Anyway,
a
all right, we will not waste time on that again. Go to the next provision.
39 is the principle for determining the ceiling area. My lord, the following principles shall be followed, namely homestead land or tank with their embankments or both to the extent of 3 acres in the aggregate shall not be taken into account. That your lords may kindly keep in mind. That is
homestead lands means?
My lord, where it is maybe dwelling house or apartment dwelling house.
In the village, they will be residing in some village area that houses are built like non-agricultural land.
Those are non-agriculture, but used for either house site or pit for house.
Or apartment.
Homestead definition is also there.
It's also there.
Yes.
But then,
but here
tanks
I am concerned about the tank here.
With their
embankment. Yes.
Embankments, tanks with their embankments.
Miller.
Or both.
Miller.
To the extent of 3 acres.
Miller.
In the aggregate shall not be taken into account.
Shall not be taken into account. That your lordship may kindly keep it in mind. Now,
there is a ceiling limit again, 3 acres.
3 acres will be excluded from the computation.
While computing, that means computing.
So, tank with embankment.
That will be discounted.
Maximum 3 acres will be discounted. Miller, excluded.
Correct.
That your lordship may kindly keep it in mind. I will take your lordship to the...
Your case revolves under this provision?
Yes. Now your lordship may kindly see there are 3 ceiling proceedings initiated by the Tahsildar against the petitioner's family.
3 proceedings.
3 proceedings because they held that we are belonging to 3 separate family. So 3 proceedings were initiated. They published the draft statement that these are the land which you are required to surrender. I challenge it in a revision before the Board of Revenue. Board of Revenue reversed the finding, said no, instead of 3, you started computing 4 ceiling.
4 units.
Yes, 4 units. That order I have given, my lord. The lordship may kindly come to the writ petition, which has been...
Who are you?
I am one of the person against to
landholder.
The landholder. I am the landholder. That Board of Revenue, it's page number, running page number 24, Miller.
Now, according to you, it ought to have been 4 or 3.
According to, we have challenged the 3 in order.
That is reversed by the tribunal holding that 4 you are entitled to.
Our family is entitled to 4 ceiling.
4 units.
Yes. Thereafter, again another case was initiated because that is as per the order of the Board of Revenue under Annex 1 Miller. They initiated into another case, Miller. They published draft statement. The Tahsildar. So, after in 2006, Miller. So they said that these are the lands which you are required to surrender without giving me an option to exercise my option, which are the land is required to be retained by me. So I file an application. This is a tank. Out of this tank, you have taken half of the tank for surrender and half of the tank you have allowed me to use as my house site. So I want to return the entire tank because it is necessary for agriculture use, Miller. That application was rejected by the Learned Tahsildar, holding that it is a delayed application.
You any Cut-off date was there for filing the application.
In 40 day, there was a cut-off date. Your Lordship, may kindly see section 40. 40.
40.
Capital A.
Capital A.
Mila.
Submission of returns.
Submission of return.
Every person holding land which shall include land transport the same due to provision. Either a landholder or right in excess of the ceiling area commencement of service shall, before the expiry of 90 days from such commencement, submit to the revenue officer a return indicating the parcels of the land which he wishes to retain and parcels of land in excess of the ceiling area, thereof the product surplus land and furnishing the within. Their particulars have provided that person may have made any transfer. The right to indicate parcels of land he wishes to have. So section 40 capital A says that he has to make an application to the jurisdictional authority.
Within 90 days?
Application should be made within 90 days since the date this chapter came into force.
Absolutely correct.
Application should be in the prescribed form.
Right.
Application should contain all particulars which have been prescribed in the form itself.
Right.
Let us go to the form now.
Now that form, your Lordship will find.
Must be in rules. Yes.
After the rules, they have also prescribed the format.
Even that may not arise in this case.
That may not. That only this
only question is cut-off date.
Right. That is only date.
When did your client file the application?
My application was filed in 2007.
That is much beyond 30 days of the cut.
90 days of the cut-off date. But the catch is, here the statute provides a revision. Revision was allowed. Matter was remanded. It was recalculated. Draft statement was published in 2006. And within that period, I have applied for exclusion.
No. Section says, it's a policy matter. Apex Court in Bihar case upheld the validity of such a provision.
Absolutely correct.
So, section says within 90 days
from the amending act,
reckoned from the that is 26 September 1973.
73 amending act.
Amending act.
Yes. The language is
commencement of the Odisha Land Reforms Act 73 shall, before the expiry of 90 days from such commencement, you are right. Amending act came into force when?
It was in 19, here it says 73 commencement of the Odisha Land Reforms Amendment Act 1973.
Correct. When that act came into force?
That came into force, amending act.
Mr. Panda, when that amending act came into force, when it was notified, and when gadgets were notified to the made available to the public at large.
73. Amending Act 73. That's it. That's 31st December 1973.
31st December 1973. Thereafter also further amendment.
No, that is not the point. Only further amendment is with regard to limitation.
Yes. Further amendment regarding filing of return.
Is it?
Yes.
Which is that?
That section is revealed. Subsection 2.
Any case where on the date of completion of the return under subsection 1, any proceeding for resumption under subsection 3 or limitation in respect of any important subject matters for return. Any proceeding under section 50 said it was suppressed or B is not applicable to you. 2A may be. In 20, the person who has submitted such return shall submit a revised return on the basis of the result of such proceedings. No. It only provides for filing a revised return.
I will clarify. Lordship, may kindly go through 40B, 40B thereafter.
B.
Miller.
Yeah, I saw that. 40B.
40B.
Capital B.
Capital B.
Return in special cases.
Again.
Where any person
being liable to submit a return under section 40A has failed to do so within the period specified therein, or has become liable to submit a return under section 40A as a consequence of the amendment of this act by the Odisha Land Reform Second Amendment Act 1975, or considers it necessary to submit a revised return as a consequence of such amendment, he shall submit the return of revised return as the case may be. In accordance with the provision of the section within 30 days from the commencement of the said act, provided that person against whom proceeding under section 43 have been initiated by the revenue officer. Kindly, this is the catch me. Provided that.
Where you are reading?
That 40B.
First proviso. First provision. Provided that
person against whom the proceeding under section 43 have been initiated by the revenue officer on his
suo moto.
Here is a suo moto.
Shall not be bound to file any return as required by this section. What is that 43?
43, your lordship, may kindly turn to failure to submit return to entail forfeiture of claim. Now, 43 is preparation and publication of draft statement showing ceiling and surplus lands.
That is a case where he initiates the proceeding because you did not file anyone.
Yes, my lord. Here, in my case, the proceeding was so much initiated by the Tahsildar.
Correct.
I have not submitted any return as required under section 48.
Yeah.
They have initiated 3 cases, my lord. It went to revision. Revision.
Under 43. Under 43.
43, they have initiated the cases.
1 second. The revenue from receipt of the returns of civil person or under section 40B of the Constitution of all available having a right to do so expression of the lands to be retained by and of the consulting the looks and what 43 says?
The revenue officer on receipt of the return.
No, I have read that. What it says in your words.
In my word, my lord, 43 says when there is a return filed by the landholder.
One part. Which is not your case.
No, not my case.
Where no return is filed, therefore suo moto he initiates the proceedings.
Yeah.
Then what is that ABCD? Total area of land held by the person as a landholder class 2 part of the land belongs. He has to say how many persons are there in your family, what is the extent of land you could have held, what is the excess land remaining, surplus land, specific parcels to be
retained by the person,
to be retained by the person and the total area thereof. Specific paroles comprising the surplus land
comprising the surplus land.
What is meant to be paroles? Paroles we have heard in criminal law.
That parcels.
Parcel. Whether this is a
that may be a printing mistake.
Mudra Rakshasa.
Mudra Rakshasa. After lekha parcels. Your lordship can refer the act because the books here, my lord is referring at the books are
private books.
These are printed by the publishers.
Private publishers.
Yes, ma'am.
Is it true that parole to be read as parcel?
Yes. Specific parcels.
Yes, that is.
Whether the original act itself it is like that or this is only a print mistake?
It is a printing mistake.
In original it is parcel.
But it is available on Your Lordship's website. Lordship can go through the amending act. Yes. Original is there, my lord.
In this book only.
No, any other.
Anyway, that may not be of much importance. That's not your case also. Now, your case is, now I have understood this way, little. They could not have rejected. You filed the application when?
Only after the computed that this area is, this acre of land is liable to be surrendered. That is specifying as per clause C.
That is 43C.
Miller. 43 1C is regarding the publication of draft statement.
Specific parcels to be retained with the person in the total area thereof.
After passing order under 43B,
Miller.
How can you file the return?
No, not return.
You want to retain. You want to show the land which you wanted to.
Right.
Retain.
That out of the area you have computed, suppose up to surrender 30 acres. I say that instead of land A,
B you will give.
B I wanted to retain.
For that also he says the application should have been filed by you.
That he says that since it has not been filed, it is belatedly filed, I will not consider it.
In other words,
Miller.
For claiming retention of specific parcels of land,
Miller.
Whether filing of the return is a must or not is the question.
Miller.
To put it other words,
Miller.
There are two schemes under the Act.
Right.
Subject to, because of my exposure to your Land Reforms Act is very less. First case. Although I handled other Karnataka Land Reforms Act.
There is a distinction between.
There is some distinction. There is also sealing provision, section 66, but it is a bit differently worded. Anyway, what the authority says is, since you had not filed the return in time, you cannot say that I will retain particular pieces of land. That contention is not available to you, is his version.
Yes, Mr.
What you say is, whether sealing proceedings are instituted because I may refile the return, or because I did not file the return, but so moto you instituted.
Miller.
Either way,
Miller.
Right to retain particular pieces of land remains intact.
Yes, Miller.
And I can claim it.
Miller. That is in my submission before you.
Appears to be that way.
Miller.
Otherwise, that will give, if we read 43(1)(c), if that right is not conceded to you,
Miller.
Then it gives discretion to the Tahsildar, saying, no, you should retain only that land, I will take this land.
Yes, Miller.
That will be hurting the interest of the right is your country.
Absolutely. So the right of choice is always with the landholder, not with the revenue officer, who will take away the land.
What the Tahsildar says, had you filed the return on your own, it is applicable, otherwise it is not applicable.
No, not that way. He said that you have, since 2006 it was finalized after the remand by the Board of Revenue. So your application in 2007 is hit under section 48 or belated.
Was it? No, two things. Is it which you filed was a return or the application to exercise choice of retention?
Only exercise choice of excluding one piece of land.
What do you say?
He did not file any return within this
the requirement of filing the return.
Prescribed period.
Sealing proceedings arise in two situations. Where he files the application, that is return you call it.
Yes.
He files the return. Where he does not file the return, but the authority himself will institute those proceedings. These are two sets. Okay. Either way, the excess land will vest in the state.
Yes.
He is entitled to a choice, saying that I own XYZ lands, I will retain Z land, I will give up X and Y lands. How can Tahsildar say, no, you have to have X land, Y and Z lands will go to the state? That is not the object of this act.
Because of the passage of time, it was crystallized, my lord. Because he did not within the stipulated period of time, he did not turn up. Everything was settled.
The question.
And a reopening of the case, my lord.
No, not reopening. Everything will remain intact. In either case, he loses the land, and the government becomes the owner of the land. That becomes a land bank of the government. In either case, they are forfeiture proceedings.
Yes.
It is a kind of forfeiture because I am not sure that you will pay any compensation for excess.
No compensation.
Therefore, it is a forfeiture.
Yes.
Forfeiture clause has to be strictly construed. Said the effects clause. Because, I'll tell you the reason. It is right to property. And it was a fundamental right when this amendment was made. Till 78. Only in 78, the fundamental right without a way.
42nd Amendment.
42nd Amendment. Went to 300 capital A.
Yes.
But as on the date this happened, it was his fundamental right. If that is so, you have to respect the right of the right to retain land of his choice, and you should take out other land.
But the Honorable Learned Single Judge did not have that scope of going into merit of the case that exhaustively your lordships are delving into, but only on the technical aspect, the
limitation question will not arise. Limitation is prescribed for filing of the return.
Yes, it is that.
If no return is filed,
then the other
proceedings will begin. In either way, he loses the land, state becomes the owner. Therefore, option to retain land of his choice and give up the land of his choice, that option is not marred by the proceedings initiated suo motu. How learned single judge treats this point?
No. He has not
reached at
He
all.
has not considered, therefore, before you.
Only on the question of limitation he has considered.
Question of limitation arises only when he files the return. But option to retain the land will continue because of 43(1)(c). See that?
42
specific,
also. 42 also.
43, kindly come to 43(1)(c). The specific parcels of land it is, perhaps.
42
42 is the question of submission of return. Here there is no question of submission of return.
No, failure to submit.
Failure to submit
That is how
forfeiture of claim.
To entail forfeiture of claim.
To submit the return or submits the return which he may consider
Contemplated 43.
See that? The restrictive provision is 42.
Yes.
B. If he does not file the return or files a defective return, what amount he will get is 50% of the amount which he would have got had he filed the return. It is not free. For the surplus land, you are being paid compensation.
No, it is only the regarding the produce.
Not land at all.
Not land.
Even then, this logic will inure to your benefit. Kindly read, provided that the amount payable for the lands declared to be his surplus land
amount payable for the land, not the produce of the land.
Milord, that your lordship, it may be, your lordship may kindly turn to, my learned friend has only referred 43. Thereafter 44, if your lordships read, it will clarify whatever lordships has taken the view, that is apparent from 44. 43 is preparing draft statement. 44 is for final statement.
On the termination of the proceeding, section 43, office shall by order confirm the draft statement with such alterations or amendments as may be been made under the said section.
An appeal against the order of revenue officer.
No, that is appeal provision.
Milord.
So what?
Thereafter, Milord. Subsection 3, Milord.
The draft statement has confirmed as modified as when it shall be published in such manner and for such period as may present as the expiry of the statement shall be final and concluded for period. No, it becomes final.
The draft statement which was published under section 43.
With variations,
with the variation of order of appeal.
That variation you may be, because you indicate I want to retain this land.
Milord, that variation only arises because in a revision, the order has been reversed. The computation has been reversed.
No.
Milord.
So against the draft, you have moved in a revision.
Yes. Against the Board of Revenue in Annexure 1 said, no 3 proceeding.
No, Board of Revenue, you challenged which order?
The order of the revenue officer preparing the draft statement making that this much of land is liable to be retained by you, this much of land is liable to be...
that you had challenged.
I have challenged.
That means 43 order you had challenged.
Yes, in revision.
The only question is this, whether to seek retention of particular land, although you are agreeable to give up the surplus land, whether that privilege is available only when you file the return, or that privilege is available even when the surplus proceedings are instituted. So
that will be this Honorable Court went to the extent of saying that even at the time of vesting also, when it is taken over and when it is tried to be, the surplus land is liable to be distributed at that stage also, I can exercise my law.
No, that is the only question is at what point you can exercise. The question is in which proceedings. That is not decided in that judgment.
That your lordship kindly have a...
No, the question is, brother, kindly do send to me. This little, we have just seen it. Whether that decision, I have not seen that. Whether that decision discusses the difference between suo motu forfeiture proceeding or forfeiture proceedings on the filing of your return.
No, Milord,
whether that aspect is discussed.
Milord, no. That distinction has not been made. But there, my lords have said that when the order in revision was passed,
then variation has to take place.
A variation has taken place. At that juncture also,
you can exercise.
I can exercise.
That's true. Question is, at what stage of the proceedings is discussed by this judgment? But we are discussing not the stage in which one of the two.
So whether suo motu or on a return.
That is the question. That is not answered.
That has not been answered. But that was a case initiated under a suo motu.
On return it is.
No. Suo motu.
Is it?
Yes.
That question is not answered, though it was in the same set of facts.
No. That was only that judgment. I have given.
But that question is not adverted at all.
No.
Not raised at all.
No, not raised at all.
Any other case, any single judge, all these years, that question has not cropped up before this court.
No, not cropped up.
What was the question framed?
Lord, the question frame your lordship will get it para 4.
Statement has been made final.
There also statement was made of canal and land was distributed.
That question is not raised.
No, that question has not been raised.
At what point of time you can seek retention of the land is discussed?
Yes.
In which proceedings you could have retained land is
That has not been considered. That has not been.
That's your case.
Yes.
38, 39, 42, 43, 44.
And some provision of section 45 and relevant rules may be necessary for your lordship.
Rules, what the rules say?
My lord, there are the rules 29, 30 are also required to be referred, my lord.
39. 39.
29.
29.
No, not 29. 30. 30.
30. Publication of draft statement under subsection 2 of 43. 43 is not so, that is so motor proceeding.
43 is so
motor proceeding.
My lord, that 29E, 30. And
29 also.
29E, my lord.
Capital.
The draft statement referred to subsection shall be prepared in form number 13. 13.
And
publication of draft statement. Copy of the draft statement is sent by register document due to the person to whom it is. See, subsection 2, Mr. Panda.
My lord.
Subsection 2 enjoins a duty on the officer to send the draft statement to the landowner. What for?
Yes, ma'am.
It is this only.
Yes, ma'am. Simultaneously sent, registered post with acknowledgement to the person whom it relates to, together with a notice intimating such person that objection, if any, to my lord. That opportunity is there.
Then he will have 30 days to make claim. Only retention of land, not return. Return question will not arise.
And choice also.
Choice also. Only choice will arise at 30 rule 2, sub rule 2.
Sub rule 2. Yes.
C. 3 gives opportunity of inspection of your records by the landowner.
Yes. Yes.
What do you say?
So these things have not been taken place. So therefore, it is to be remanded before the authority.
Why am I remanding again?
Because it has to be done. Because the mandate.
It has to be worked out.
Yes. What worked out?
What do you say about the proposal of the learned AG? Remand.
Yeah, it has to be considered.
Because authority has to consider.
Yes, authority. Yes.
Once it does its exercise, then we can.
Yes.
Since
they refuse to exercise, Miller. They refuse to exercise
jurisdiction. Refusal to exercise.
Yes.
Discretion.
It is actually denial to exercise jurisdiction.
Absolutely.
That divesting of it.
The color.
No, not colorable, but divesting of they have refused to exercise.
You took up that matter in appeal to whom?
Board of Revenue. They asked in the Revenue Forum.
Board of Revenue.
Yes, madam.
And it also held you did not file a return in time, therefore you cannot claim this choice.
No, that order is not neither applicable nor revisable. Therefore, I challenge in a writ petition before the Honorable Single Judge. That being rejected,
how single judge treated the matter?
Lord, so may kindly see the impugned order. Para page 68, Millard. Millard, the 6.1 Millard.
No. Para 5. Our contents was recorded and it was accident.
That was content.
It was accident too.
No, the contention, various contention were recorded up to para 5. 6 is the conclusion. Having heard Lord and Counsel appearing for the parties and considering the submission made, this court finds that the petitioner herein moved an application purportedly filed under Section 40A of the Act on 11/3/2010. That is a mistake, Miller, under Annex 3. As provided under the said provision, an application is to be filed prior to expiry of 90 days from the commencement of the Orissa Land Reforms Act 73, which was notified on 13 April 1974. It is found that the application in question has not been filed within the prescribed.
They proceeded on the ground
Wrong.
that for claiming the choice of retention, filing of return is a must.
Mandatory.
Exactly.
If it is suo moto, you are completely excluded. He will grab the land whichever Tahsildar will want.
Yes. On that premises.
Exactly, that has happened in the decision. I have referred. In the previous case, the Tahsildar took up the best piece of land and said.
And he had distributed also. Before the final notification was issued. Just assist me by giving the dates.
Date charts, that is very essential in this case.
A date chart, but that is not exhaustive. I have given a list of dates and events. Appendix 2 to my read.
Do you have one hard copy with you?
Yes,
please. In respect of all the three matters, one order.
One order, because there is a common
order.
Yes, four matters. There are four writ appeals.
Four writ appeals.
4 writ petition, 4 writ appeals.
But subject matter is one.
Subject matter is one.
Judgment is different.
Same common judgment.
Common judgment.
Since there are 4 OLR proceedings, so I have filed 4 writ appeals.
Right now, this is only a draft for our consumption. Then I will finalize that case. We will finalize that case. Right now. This kindly be seated. Sit down and answer. This intra-court appeal seek to call in question a common order of the learned single judge of this court, whereby
there is some doubt is arising regarding the number of the writ petition. There is a year, 2 writ petition are of 2011 and 2 writ petition are of 2024.
Yes, I am clarifying that. So initially, I have 2 writ petitions were filed And when it was listed before the honorable, one of the honorable judge,
He said by two.
he said when it is arising out of 4 proceeding, how 2 writ petition was maintained.
Therefore, two more. Same order.
Same annexure.
Original was in 2011.
Yes, but it was also taken up consideration in all the cases.
In the improved order.
Common order in all these matters, 2011 matter and subsequently filed matters also.
Common order.
Common order. All the 4 petitions are disposed of by one common order.
Yes, ma'am.
Order dated 13/9/2024, whereby appellants WP numbers, all they are there in the order, common, have been negative. First, in the said writ petitions, the appellants had called in question whether those orders by the board, not board, authority only.
In the impugned order before the honorable single judge was of that of the Tahsildar. Miller.
Common order, that also.
Yes, Miller.
Or different orders.
For 1 second, Lordship may kindly peruse paragraph 4 observation of the Learned Single Judge. Learned counsel for the petitioner contended that taking recourse of the provision contained under section 40 capital A of the Orissa Land Reforms Act, he has himself acceded that he has taken.
There cannot be a question of that one. He may say so many things. You may so many things.
The fact
judge has to do justice depending upon the facts available to us. Because no estoppel against law.
That led to the Learned Single Judge to enter into that premises. That
called in question, Tahsildar's order dated, kindly advert to us, brother. 28/10/2010, passed under section 43 of the Odisha Land Reforms Act 1960. Whereby the appellants claim to retain particular lands and give up the excess lands has been negative on the ground that the applicant had not filed any application / return under section
40 capital A.
40?
Yes.
No. 40 is determination.
40 capital A.
40 capital A.
Submission of returns.
You are right. Return, not application. Return under section 40 capital A 1 of the Act. First one. Next paragraph. Learned counsel appearing for the appellants, having taken the court through the provisions of
Chapter 4 of the Act submits the Act and rules 29E and 30 of Odisha Land Reforms into brackets General Rules 1965 succinctly argues that his client is ready and willing to give up the surplus land as has been determined by the Tahsildar under section 43 of the Act. 43 is followed by final order is passed under which section? 44B. Eventually resulting into the finalization of the proceedings under section 44, semicolon. However, the scheme of subject chapter gives a legal right to the surplus holder of the land to retain such of the lands which he wants to and to give up such of the surplus lands which he wants to give up. First up, this important aspect having been wrongly decided by the learned single judge, interference in the appeal is eminently warranted. First up, he laces his argument on the legal premise that whether the surplus lands proceedings be they initiated suo motu by the authority or be they initiated on the filing of return by the surplus holder, the choice to retain certain of the lands is not taken away, nature of initiation of such proceedings being irrelevant for consideration. First, learned AGA appearing for the OPs opposed the appeal, contending that for claiming choice to retain the lands, does not avail to a surplus landholder who failed to file the return under section 40 capital A 1 of the Act. First off, admittedly, no return having been filed, no privilege can be claimed by the appellant, adds he. First off. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we are inclined to grant indulgence in the matter as under and for the following reasons. 3.1. Regardless of the thickness of the paper book and several points urged at the bar, the jugular vein of the case is
whether for exercising the choice of retention of surplus land, the filing of return by the surplus holder is a sine qua non. First one. The answer to this question has to be in the negative because then A, B, C, D. 1. The right to property was the fundamental right till it was relegated under Article 19(1) H. As it then was, till the enactment of 42nd Amendment in the year 1978, whereby the same was relegated to a non-fundamental right, but with constitutional guarantee under Article 300 capital A, as expansively discussed by the Apex Court in KT Plantations versus State of Karnataka, or State of Karnataka versus political, just looking, 2011. However, these proceedings, when that order under 43(1)A was made?
It was in 2006.
The proceedings were initiated when?
It was in initially it was 74.
74.
Miller.
Give the date.
Here.
That is 145 of 74.
Miller.
145, 146, 147, 144. And 454.
74. Next one is date 9 initiation.
First, with that as it may. Chapter 4 regulating vesting of private land into state on being surplus came to be introduced to the 1960 Act
in Act 29 of 1976.
Why the Amendment Act 29 of 1976? 76?
Miller.
No.
Your Lordship, may kindly say, sir. Miller?
70. 73.
73, my lord. With effect from 31/12.
Declare date. No,
Amendment.
76.
31/12.
No, it came to be introduced in 1965. But 37 came to be introduced, modified in 76.
Your family description has undergone a change in 76. But this
introduced by the Act number 13 of 1965. First up, extensive amendments were made to the chapter by Act number 29 of 1976 with the effect from
with the data. No. Sorry, come on, blood.
76.
No,
73.
I'm 73.
No, 76 amendment.
Yes. 76.
40A is introduced when? 40 capital A.
40 capital A was introduced. 1 minute, please.
Three is also amended. Act number 9 of 74. 9 of research,
Ordinance was made in 74. Act 2 of 74. 2 of 74.
Ordinance is also law for 6 months, followed by amendment.
Amendment. That is Act 2 of 1974.
Act 2 of 1974.
Provided for the child for a consumer.
Anyway, just the act so and so, so and so. Section.
It was came 40A was introduced on 12th July 1974.
12th July 1974.
As revealed from the amending Gazette.
Full stop.
It was got the assent of the Honorable President on 11th July 1974, published in the Extraordinary Gazette on 12th July 1974.
The chapter deals with sealing and disposal of surplus land. First off, Section 37 is the dictionary clause of this chapter, which inter alia defines family. First off, Section 37A prescribes the sealing area in respect of a person to hold land. That is 10 standard acres first off. However, the proviso relaxes it to the maximum of 18 acres. Maximum of 18 acres when the family is large. First off. Section 37B disentitles any person to hold in whichever capacity land in excess of ceiling limit. First off. Next paragraph, small paragraph. Section 38 enacts the exemption clause with which we are not concerned. First off. Section 39 prescribes the modalities for determining the ceiling area on certain principles. First off. Section 40 prohibits alienation of surplus land after the 19 after the cutoff date, namely 26/9/1970. No, cutoff date is not 70, 73.
73.
When that act came into force?
31/12/1973.
Cutoff date is 31/12/1973. After Act number 29 of 1976 is enacted. First one, it is bit retrospective. It has bit retrospective effect. First one, Section 40 capital A, which is the jugular vein of this case, enacts the provisions providing for submission of returns by the surplus holder. Section 40 capital B mentions of special cases for submitting the return. First, Section 41 fixes the responsibility of submitting return on certain entities like a guardian, where the holder is minor, or head of the family, or where holder is a joint family. First of all, Section 42, which is of some relevance to this case, speaks of the consequences of failure to file the return under Section 40 capital A. First of all, next paragraph. Section 43 empowers the jurisdictional revenue officer to treat the return filed by the landowner, surplus holder, or to initiate suo motu proceedings where such a return is not filed. First up. What are the particulars to be contained in the draft statement? Whether it is a suo motu proceeding or return-based proceeding, is contemplated in this provision. It gives an opportunity to the surplus holder, even in suo motu proceedings, to suggest a modification of the draft statement. First one, Section 44 operationalizes the draft statement by giving finality to that. First one.
Section 45 provides for vesting of surplus land after the statement is finalized under Section 44. It is preceded by a declaration under Section 44A as has been prescribed under Section 57A before finalization of statement under Section 44. There are other miscellaneous provisions with which this case is not much concerned. First up, rules 29 capital E and 30 elaborate the procedure of the proceedings under Section 43. First up, this below that one, all this is a thumbnail description of Chapter 4. First up, main paragraph. The vehement submission of learned counsel for the appellant that surplus lands have to vest in the state strictly in accordance with the provisions enacted in Chapter 4 has force. First up, whether first up, it cannot be gainfully argued that right to property is not a constitutional right. First up, the institution of private property is recognized under Article 300 capital A. First up, the provisions of Chapter 4 are in a way or is not necessary, in a way intend and effectuate curtailment of this right. First up, therefore, the curtailment has to be strictly in accordance with law. First up, one of the rights given to surplus landowner under the provisions of this chapter is a choice. First up, in other words, even a person holding the surplus land, can tell the jurisdictional revenue officer that he would retain particular lands that would be within the ceiling limit and give up lands of his choice that are surplus to to the state. This is a kind of privilege given to the surplus holder, maybe to pacify him when he loses the land almost free of cost, or by way of forfeiture. First off, there is a force in the submission of learned counsel for the appellants that the choice avails to the surplus landholder regardless of nature of surplus proceedings contemplated under the provisions of this chapter has force. First off, in other words, even when the surplus holder has failed to file the return, and eventually suo motu proceedings are instituted by the revenue officer, such a choice avails. First off, there is nothing that suggests in the provisions of this chapter that non-filing of return would take away the choice available to the surplus holder when suo motu proceedings are instituted. If the legislature intended that such a privilege or choice should not avail to the surplus holder, an elaborate provision would have been made to that effect. However, we do not see any such thing. Next point. As already mentioned, Section 40 capital A provides for filing of return by the surplus landholder. First off, that return has to be filed within the limitation period, which is 90 days reckoned from 31/12/1973. That is, when Act, which is the Third Amendment, when the chapter was introduced. First off, Section First off, a form is prescribed under the rules, and the application has to be in the said form. Section 42 speaks of the consequences of failure to submit the return.
under section, inter alia under section 40 capital A. First off, what would happen is that the revenue officer has to obtain all necessary information from the concerned agency and initiate the proceedings, suo motu proceedings under section 43. Provision to section 42 specifically says the consequences of non-filing of return. First off, it says that the surplus holder shall be entitled to only 50% of the compensation amount, bracket into bracket amount payable for the forfeited land, which otherwise he would have got 100%. Yes. Here is the question. First, when the law says what would happen when certain thing is not done, come on, it is not within the province of authorities to say something more will happen. First of all, an argument to the contrary would put the authorities above the wisdom of the legislature. First of all, in other words, there cannot be a consequence of failure to file the return beyond what the legislature has enacted in section 42. First of all, to put it differently, the failure shall not result into forfeiture of the choice for retaining certain lands and giving up other, of course, subject to adhering to the ceiling limit. First of all, this aspect of the matter, this view of the court gains support from the tripartite case is a division bench judgment.
Yes, yes, it is division bench.
This view to some extent gains support from a coordinate bench decision of this court in Naresh Chandra Tripathi versus Revenue Officer cum Additional Tahsildar. What is citation, sir?
Volume
1977.
Volume 44.
Volume 44.
CLT.
Katak Law Times, page 449. 144. 44. Roman is there, na? First of all. Now come on. Wherein it is observed that
it is observed this one. Take this. Only that sentence. Next paragraph. There is another reason as to why the submission of appellant's counsel gains acceptance. As mentioned above, Section 43 provides for both the proceedings, both the types of proceedings, namely return-based proceedings and suo motu proceedings. First off, subsection 1 specifies what all to be done in these proceedings. First off, clause C of 43(1) reads as under. Aliens. Sit up, sit and work. When working, should not stand up. Done. Here. Subsection 2 specifically provides that the draft statement prepared under subsection 1 shall be sent to the surplus holder and his objections, if any, shall be heard. First off, this is indicative of the legislative intent that the landowner can seek alteration of what has been stated in section 43(1)(c), which mentions about retention of certain parcels of lands and giving up of other. Rule 30, sub-rule 2, 32, also provides the same. First off, sub-rule 3 of this rule gives a right to the landowner to apply to see the entries in the records, inspect the entries in the records, and take extracts from them to the extent such records relate to section 43 proceedings. First off, it cannot be an empty formality. First off, it is to facilitate the surplus holder to make an informed decision
as to whether he retains particular lands, giving up other enlisted in the draft statement of the revenue officer prepared under section 43(1). First off, an argument to the contrary would run counter to the fifth and substance of several provisions of this chapter, and therefore do not merit acceptance. First off, next paragraph. All the above being said, learned AGA, Mr. Panda, having resisted the appeal on the grounds now treated above, he is more than justified in contending that this court, having limited jurisdiction, supervisory jurisdiction, under Article 227 of the Constitution, 226 having been ornamentally enshrined in the pleadings, cannot decide the matter on merits. First off, he is right, because several special information the official has to treat, and he will have expertise in the domain. First off, an appellate court, an intra-court appeal of the kind also will have the constraint which the learned single judge had while deciding the writ petition. First off, therefore, we do not propose to undertake the exercise which the special authority nominated by the chapter has to undertake in the fitness of things. First off, in the above circumstances, this appeal succeeds. Secondly, the writ petition number so and so, succeeds. First off, the impugned order of the learned single judge is set at naught. Semicolon. Appellant's WP numbers so and so having been favored, the Tahsildar's order dated. What is the date of the order? Kindly sit and answer.
8/10/2010. 1 minute.
No, it's my order is
correct.
It's 9/28.
28/10/2010.
Common order in all the four. Tahsildar's common
dealt in a common
order dated
28/10/2010
is quashed. Semicolon. Matter is remitted back to the portals of Tahsildar. Which Tahsildar?
Tahsildar both.
So and so for consideration afresh, keeping in view our observations made herein above. First off, an opportunity of hearing shall be given to the landowners and other stakeholders First off, these old proceedings shall be accomplished by the Tahsildar within a period of 6 months. First off, all contentions in that regard are kept open. First off, courts made easy.
We're extremely grateful to your lordship for the exhaustive judgment. That.
No, this requires a little more. These are only my
painstaking exercise your lordship undertook.
Lot of treatment because
refinement has been.
There are 2 judgments of the apex court. One from Bombay, another from Karnataka, which treated the forfeiture proceedings, their nature, etc. I have to do research now. Your research is not sufficient, nor yours. Yes. Only one paragraph you have to add. The question which is the jugular vein of these appeals was not framed in the writ petitions.
Yes.
First one. However, question would definitely arise on the basis of facts emerging from the record. First off, a writ court cannot say, be it in original side or in appellate side, that a particular point was not argued and therefore the law applicable to the facts demonstrated will not be considered. First off, it hardly needs to be stated that the Constitution is meant for maintaining practical rights of the citizens and not for jurisprudential theories. First off, little language, etc. it undergoes. I may add 1 or 2 rooms depending upon the 2 judgments.
Item number 37.
All matters.
With the lordship permission, my lord. Item number 37. My lord, it was, I had mentioned it
today. No, today you have called me to your bar and now you want.
My lord, I had mentioned yesterday, my lord, taking into consideration the order passed in the content proceeding. Taking into consideration the order passed in the content proceeding, the lordship had been pleased to fix the case today. May I pray, my lord, this matter will be taken up tomorrow? Because, my lord, it is...
When content proceedings are slated when?
My lord, that is in the February month, my lord.
February?
Yes.
A lot of time.
6-2, my lord.
May I only...
6-2.
We'll have it on 4th of February.
Lord, may I mention item 30? Your lordship, item number 30.
Urgent matters mentioned. Item matters, etc.
I'm suffering an expert interim order for last 2 years, which was obtained against me. I'm a bank.
2 years you have waited. Wait for 2 weeks.
Possession was stayed, not the under-sufficiency. That's also on the
Item 26, my lord. Item 36. Item 36, I have...
Look into the urgency, depending upon urgency.
My lord, item 36, my lord, I succeeded in the lower court, my lord. I'll succeed. There is a stay. I have already paid 5 crores, my lord. I'm paying all the... There is a fraud on me by the bank. It's a...
bank has preyed on the...
Well, that's my case. I've got all the judgments, my lord. I've got 7 judgments. I've done a compilation.
Fraud on me on the bank.
I only pay my any day, my lord, as your lordship pleases.